Yes, yes. Item number 47 and 48 in error. Come wrongly 34 times. Should be count code number. Wrongly listed
47.
47 and 48.
Yes.
Wrongly listed
The review against whom?
my lord, Honorable Sir Chair.
47. Connected.
Yes.
Number 47, 48. It has been submitted by the learned counsel, Mr. K. Kolcha, that instant that a review is sought against an order passed by Honorable Mr. Justice K.R. Surat. Taking into account the above, matter be listed according to the appropriate.
Item number 44.
Hmm.
This we participant for withdrawing the review with the honorable court.
You want to review?
Withdraw the
Withdraw the review petition. Your name?
A. Chakravarti.
Ms. A. Chakravarti, the learned counsel appearing on behalf of the review petition submit that the petition does not wish to further review, taking into account the above review and withdraw. Eight, in the order passed. Eight, I should withdraw. Eight, has those in the withdraw.
Yes, this your lordship, like to make item 22. Item 22.
22.
22.
Yes.
Senior type
Yes, tell me.
mentioned not
Why?
my senior type of
Huh?
Senior type of person.
Senior is who?
Ida.
Who is leader?
Tuta.
Where is he? It is for what? I for what? Condonation of delay. We'll see when the matter comes. Next.
As expected by the appellant, I want to withdraw the item number 7.
7.
7.
You want to withdraw?
Lordship.
Mr. Gita Koti. Mr. Gita Koti, the learned counsel appearing on behalf of the appellant, submits that the appellant wishes to withdraw the instant appeal. So accordingly, the instant appeal stands dismissed on withdrawal. I is in consent, I stands closed in view of the withdrawal of the
That is detected as posted instructions. It's within what time under the department to take the deposit. The line of that I have written a letter.
You have written a letter.
We communicated. They come back to us with telephonic instructions. I think that the amount in question, the release of the same would amount to a supplementary fund request.
So you let the authority take over it. We are not concerned with all this. The order which has been vacated,
yes,
rightly done. We are not interfering with it.
The only thing that the instructions to receive that be recorded. Only my instructions to receive that will be recorded.
Not necessary. I gave you an opportunity earlier to the effect that as to whether you are in a position to now give.
Yes.
We are not. Then forget about it. We are not concerned with. We are therefore going to see as to whether the order passed by the learned trial court or the learned court was wrong. All right. Let's see whether it's wrong or right.
Any payment can only be made after 10. That is the instruction.
But I can't stay. You can very well approach. You withdraw this and make the submission there. Why you are not making that submission the same thing? You see, the
but
problem which arises out here is this. I am not going to look into as regards whether you can pay or not and grant the stay. This court is not going to. You can very well approach and say that, look here, model code of conduct is going on, and under such circumstances, kindly stay till this thing, and we are ready to deposit it on 10th or whatever may be. The submission there, court will listen.
but that liberty may be granted.
Mr. B. Talukdar,
He told me,
B. Chaudhary, the learned counsel appearing on behalf of the petitioner, submits that the Forest Department, that the petitioner herein does not want to press the instant petition. He submits that he may be given the liberty to make necessary application before the
additional district judge
court of the additional district judge number 2 Kamrup Metro, before whom the proceedings under section 34 is pending. 34 of the Arbitration and Conciliation Act 1996 is pending, to make appropriate submission as regards certain concessions. So, taking into account the above, the instant petition stands dismissed on withdrawal. The dismissal of the instant application on withdrawal shall not preclude the petitioner to approach the additional district judge number 2 Kamrup Metro to seek certain concessions, certain accommodation for the purpose of depositing the amount so direct. It is observed that if such petition is filed, the learned court shall consider the same as per the provisions of law without being influenced by the leave so granted.
Manoj, market factors of the succession with regard to the code of conduct.
If you very well say, not
Give
that
you
what none appears on behalf of the appellant on cause. From the perusal of the appeal memo, it reveals that the appeal is directed against the order dated 29/4/2023, whereby the application so filed under Order 7 Rule 11, read with Section 151 of the Code of Civil Procedure 1908 for rejection of the plaint was rejected. It is relevant to take note of that no appeal lies against an order rejecting an application seeking rejection of the plaint. Under such circumstances, the instant appeal stands dismissed as not maintained. It is, however, made clear that the dismissal of the appeal as not maintainable shall not preclude the appellant to avail such other remedies available. If other questions. This is an appeal under section 23 of the Railway Claims Tribunal Act 1987. Against the judgment and order dated 14/6/2023 passed by the Learned Railway Claims Tribunal Guwahati bench in OA Roman 2 capital Roman 2 U dash 71 of 2022. The appeal is admitted. Call for the records. Lists. Ms. RDB appears on behalf of the respondent
Correct.
and accepts notice. Accordingly, no further notice is required to be served upon her, upon the said respondent. List the matter for hearing upon receipt of the reports.
Okay.
Yes,
Lordship, along with this appeal, Lordship, there's an analogous appeal. It was listed on 1/5/2024.
that has not come.
There is not come, Lordship.
Directed that matter to come.
Lordship.
What is that?
There is 72, Lordship. FAO 72 of 2022. There was a specific order of the
What is the FAO again?
This is the against order of status quo. Both the parties were directed to maintain status. So I am not on that. But there's an observation in the injunction application regarding possession. So that is to be looked at. So both the matters to be come together.
So what remains?
Lordship.
The observations so made shall be always, shall not affect the trial. That's all.
That is necessary.
Oh, we passed that.
Lordship.
Then.
Look.
This is an appeal under Order 43, Rule 1R, read with Section 104 of the Code of Civil Procedure 1908, against the order dated 26/2023, passed in Means case number 381 of the 2023, arising out of title suit number 26 of the 2023,
Look.
wherein the learned court of the civil judge number 1, Kamrup Metro at Guwahati, directed both the parties to maintain status quo over the suit land till the disposal of the title suit number 26 of the 2023. This court have duly perused the impugned order dated 26/2023 and is of the opinion that the said order does not the said order does not require any interference in as much as the order does not in as much as the order has been passed by taking into account the principles for grant of injunction. Mr. R.K. Bhuiyan, the learned counsel appearing on behalf of the appellant, submits that the observations so made in the said order should not, however, affect the decision in the suit, taking into account that the said order has been passed only for the purpose of deciding an interlocutory injunction. This court makes it clear that the observations so made in the impugned order dated 26/2023 shall only be construed as in relation to the consideration of the injunction application and nothing further. Under such circumstances, the said observation shall not affect or influence the learned trial court in deciding this. With the above, the instant appeal stands disposed. Yes, what is this?
Hello. Yes, I could take it.
Landlord tenant.
Landlord tenant.
You are the
I have the tenant according to them, but I say that I have not tenant. Actually, their case is that they have purchased the land from my power to me, my power to and after purchasing the land from my power to they practically allowed me to stay in my house, and thereafter they had made a tenancy agreement for 1 month with me. For 1 month, agreement was made with me, and I did not pay the rent. And for that, I have not for eviction. That I am defaulter, and that they are bona fide that. So here is the question. My question is that I am not on tenant. I am on the sale of the land. I am on the sale of the land by my power. I say that
have you filed a suit?
What?
Did you file a suit?
they have filed the suit. I have contested.
You have contested.
Okay.
No. Have you filed a suit challenging the sale deed?
No.
Then?
That has been challenged as a defense of.
Maybe,
as a
but
defense.
then also that the
Only-
deed
only
of sale remains. You have not challenged it, you have accepted it.
No, I have challenged it as a defense.
When was the
Yes,
deed
it
of sale made?
My deed of sale
And when was the suit filed?
in the year 2007 a lot.
Suit was filed, you didn't file, you had the due knowledge, you have not challenged it. The period is 3 years. And if that landlord tenant relationship is not there, then also one can very well ask you because he is the owner.
If he is
Rightly
owner, he can
passed.
evict me.
Then you can
He
very
owner,
well, maybe a landlord tenant issue may not be there, but then also it can be done.
Yes,
In fact, yesterday I was looking into a judgment. It's a very interesting judgment on this point. It was held by the Constitution Bench. It is reported in 1965, I suppose, Supreme Court. Very interesting. Bhagavan Prasad. There the issue arose was this, which is similar to here. The issue arose is a suit was filed by the landlord for eviction on the basis of default and bona fide requirement. The trial court held that there was a tenancy agreement, and as such decreed the suit for ejectment along with payment of mean profit. The first appellate court confirmed the decree for ejectment, however, holding that there was not a tenancy. And therefore, the mean profit was struck off. So the issue before the Supreme Court was whether a judgment could have been passed, thereby confirming the decree of ejectment without taking into account that the ground on which the suit was filed was negative by the first appellate court. Then at paragraph number 10, the Supreme Court said that the parties very well knew that it was a suit for ejectment. So under such circumstances, pleadings and evidence were duly given. There was a document of title which was there and the other side didn't have. So under such circumstances, it was rightly passed and as such did not interfere. Your case comes squarely within the ambit.
Issue is there. That in that suit, all of the issue has also been decided. That in the year 1965,
They have also, when I denied the title, they have claimed right and title on the page. So the title has been, Learned Munshi had dismissed their holding that they could not prove their title. Thereafter, in the first appellate court, unfortunately, during Corona period, the learned counsel for the defendant, it did not appear in the case up to Corona. It did not appear. Since 2020 itself, it did not appear, and the suit had been heard in the absence of the defendant respondent. So, in that way, he could not get opportunity to defend his case in the first appellate court. And
So the decree was in your favor,
no,
initial decree.
initial degree was in favor, but in the appellate court, after COVID-19, my advocate did not appear in the case. He did not appear since January 2020 itself. So thereafter, he did not appear. However, that at least the court should have been considering the pandemic and considering that this pandemic, the advocate did not appear. One opportunity must have been given to the
Well, appeal, there is some person's name is there, Pallavi Burwa. Pallavi Burwa is there.
in the judgment,
In the judgment, it is shown.
but nobody appeared.
Nobody appeared. How can you say that Pallavi Burwa is there? S. Das is there.
Counsel is mentioned, name of counsel is mentioned, but
Then the name of counsel mentioned, that is enough.
I don't have that. That is it there too. On the fifth of appeal memo notice, the defendant respondent to appeared to the net did not appear in the appeal.
Huh?
Page number 15,
15.
55 two.
Yes.
But that is my absence actually after COVID-19, the advocate did not appear. That was the problem.
You cancelled the power of attorney in 2008, whereas the sale deed was done in
My lord,
2007.
actually, that was not required to cancel because already sale deed was executed on some wrong legal advice. It was cancelled. And
can't help you.
that cancellation goes against him. That cancellation goes against him. That cancellation made his their case easy. It was not required who has advice I told to, but that was wrong advice. fourth part is that in Pavarni there was no boundary of land. But in Tellit they have given full boundary. So how the agent can go beyond the authority given to him?
There is no challenge to the sale deed. The problem arises there, Mr. Sharma.
No, I have not told. Still, he has to prove his title. Na?
He has proved
He
it.
has to prove that.
He has proved it. There was a power of attorney, and on the basis of the power of attorney, the sale deed was executed. Now, therefore, you have to challenge it. You have not challenged it.
Definitely, this honorable court can see whether the sale deed was according to Pavarni. Whether
I am
sale
not
deed-
going to look into that.
No, no,
This
whether-
court is not going to go into that question of the question because of the fact that that sale deed is not the subject matter of question. Therefore, I think this is a case for dismissal right away. Third, Mr. S. Sharma, the S. Sharma, the learned counsel appearing on behalf of the petitioner. Petitioners. Petitioner. And Mr. R.K. Bhuya, the learned counsel appearing on behalf of the respondents. This is an application under Section 115 of the Code of Civil Procedure 1908, challenging the judgment and decree dated 28/4/2022, passed in title appeal number 73/2016 by the Court of the Civil Judge Senior Division number 3, Kamrup Metro at Guwahati, whereby the appeal was allowed, thereby setting aside the judgment and thereby decreeing the suit in favor of the plaintiff. From the materials also, for the purpose of adjudicating as to whether there was any jurisdictional error or the learned first appellate court had exercised jurisdiction illegally as well as with material irregularity. This court finds it relevant to take note of the brief facts leading to the filing of the instant application. The plaintiffs, where is the plaintiff?
Plaintiff, your lordship, at page 15, anchor 1, page 15.
The predecessor in interest of the respondent
Respondent.
herein. One, Lazima Begum, since deceased. By the registered sale deed number 9414/07 dated 24/7/2007 purchased a plot of land measuring 2 katha 10 lechas covered by dark number 1192 of KP Patta number 187 of village Dehen Garigao under Moza Jalukbari in the district of Kamrup, along with an Assam type house consisting of 4 rooms, kitchen and latrine and bathroom, and another Assam type house consisting of 2 rooms standing over the said land from the defendant. Through his power of attorney holder, one Mr. Osman Ali. Osman Ali?
Usman Ali.
Osman Ali. On the date of sale, it was alleged by the plaintiff that the delivery of the land and the house was, the possession of the land and the house was duly delivered. As the defendant requested the plaintiff to allow him to stay in the Assam type house consisting of 4 rooms for 3 to 4 months, wherein the defendant was residing as a permissive occupier till an alternative arrangement was made. The defendant, and with an undertaking that he would vacate the said house at any cost by making alternative arrangements. The plaintiff allowed the defendant to reside in the said house for 3 to 4 months from 24/7/2007. That is, since the date of purchase of the said land and the house. It was alleged in the plaint that for the said 3/4 months, the plaintiff did not make any demand for the house rent from the defendant. However, after the period of 3/4 months, the defendant failed to vacate the scheduled premises. Upon demand, the defendant requested that he may be permitted to stay in the scheduled premises for the month of January 2008. And in that regard, a tenancy agreement was entered into between the plaintiff and the defendant on 3/1/2008. The defendant, it was further alleged that the defendant thereupon failed to pay the rent as stipulated in the written agreement dated 7/3/2008, for which the defendant was a defaulter in payment of rent. And further, the plaintiff had bona fide requirement of the scheduled premises. It is under such circumstances the suit was filed by the plaintiff, late Lazima Begum, seeking a decree for ejectment of the defendant, his men agents, by removing their materials, articles belonging from the scheduled premises as described in the plaint, a decree for area rent, and for permanent injunction. The said suit was registered and numbered as title suit number 200/2008. The defendant thereupon filed a written statement challenging the title of the plaintiff, and it was the categorical stand that the attorney one Mr. Osman Ali was not authorized to sell the suit land as well as the house to the plaintiff. It was denied that there was that the possession of the land and the house, food land and the house standing thereon, were handed over to the plaintiff at any point of time, as well as also denied about entering into the written agreement with the plaintiff to vacate the suit premises on 3/1/2008. In view of the said categorical denial to the title of the plaintiff by the defendant, the suit was amended, thereby incorporating the relief, amongst others, of declaration of right, title, and interest over the suit land. On the basis of the pleading, pursuant to the amendment of the plaintiff, the defendant filed an amended written statement. On the basis of the pleadings, as many as 6 issues were framed, of which issue number 6 related to whether the plaintiff had right, title, and interest over the suit land. And issue number 2 related to whether there was a landlord-tenant relationship between the parties. In addition to that, issue number 3 pertained to as to whether the defendant was a defaulter in payment of rent, and issue number 4 related to as to whether the suit premises was bona fide required by the plaintiff. The learned first trial court, by its judgment and decree dated 24/5/2016, dismissed the suit by holding the issue number 6 against the plaintiffs to the effect that the plaintiff failed to establish right, title, and interest over the suit land, and only on the basis of an unproved sale deed number 9414/07, title of the plaintiff over the suit land was not established. The other issues were accordingly decided, taking into account that as the learned trial court came to an opinion that the plaintiff did not have right, title, and interest over the suit land. The question of going into the questions of landlord-tenant relationship, or for that matter, bona fide requirement or defaulter in payment of rent, lost significance. Being aggrieved, the petitioners herein being aggrieved, the respondents herein preferred an appeal, taking into account that during the pendency of the suit, the original plaintiff had expired. The said appeal was registered and numbered as title appeal number 73/2016. The learned first appellate court by the impugned judgment and decree dated 28/4/2022 allowed the appeal by reversing the finding in respect to issue number 6 and observing that the plaintiff had right, title, and interest over the suit land. Consequent to the decision in respect to issue number 6, the other issue of landlord-tenant was held in favor of the plaintiff, holding that there was a landlord-tenant relationship and the issue number 3 and 4 as regards bona fide requirement and default, as regards defaulter in payment of rent and bona fide requirement were also held in favor of the plaintiffs. It is against the said judgment and decree passed by the learned first appellate court dated 28/4/2022. The present application has been filed under section 115 of the code. I've heard Mr. H.J. Sharma, the learned counsel, appearing on behalf of the petitioner who submitted that the petitioner herein have not admitted submitted that the deed of sale dated
Yes, sir. 9414
bearing number 9414 dated
dated 24/7/2007.
2007 was honest, taking into account that the said deed of sale was executed by a person who had no authority to do so. He submitted that the learned trial court, having taken into account the evidence on record, have decided the issue number 6 in favor of the defendant on the ground that the plaintiff had failed to prove the said deed of sale. The learned counsels therefore submitted that the said deed of sale, having not been proved, the issue number 6 ought not to have been decided in favor of the plaintiff by the appellate court. And the reasons so assigned are not in consonance with law. The learned counsel further submitted that as the issue number 6 was wrongly decided by the learned first appellate court, the further findings of the learned first appellate court in respect to the issue number 2, 3, and 4 are also liable to be interfered with. In short, the submission of the learned counsel is that the learned first appellate court had exercised its jurisdiction illegally and with material irregularity. Anything else?
So, you know, there is no, so you mentioned that there is no boundary in the county, but the boundary is that.
The learned counsel further submitted that the power of attorney on the basis of which issue number 6 to wrongly decided to the learned counsel further submitted that the power of attorney which was executed by the defendant in favor of Osman Ali did not contain the boundary. What boundary? The schedule boundary. And as such, the deed of sale could not have been executed by the power of attorney agent in favor of the plaintiff. Is that it? On the other hand, Mr. R.K. Bhuyan, the learned counsel appearing on behalf of the respondents, submitted that the deed of sale dated 24/7/2007 or even the power of attorney dated 7/3/2007 have not been put to challenge by the defendant by filing a counterclaim in the suit or by filing an independent suit. Referring to exhibit, referring to the Exhibit 8, by which the power of attorney dated 7/3/2007 was cancelled by the defendant. The learned counsel submitted that in the said power of attorney, the defendant duly admitted that the power of attorney dated 7/3/2007 was duly executed by him. The learned counsel further submitted that the power of attorney was cancelled much after the execution of the deed of sale. And as such, the cancellation of the power of attorney had no relevance to the execution of the deed of sale, which was executed much prior thereto. The learned first counsel further submitted that the learned first appellate court have duly taken note of the deed of sale which was duly executed, as well as the said deed of sale was also proved by the executant that is the power of attorney holder, PW5, as well as PW5. Who's- The learned counsel, therefore, under such circumstances, it is therefore submitted that there was no illegality or material irregularity in exercise of the jurisdiction by the learned First Appellate Court in passing the impugned judgment and decree dated 28/4/2022. Upon hearing the learned counsel appearing on behalf of the parties and upon perusal of the materials on record, this court, having heard the learned counsels appearing on behalf of the parties, have heard the learned counsels appearing on behalf of the parties and have given due consideration to their respective submissions. At the outset, this court had put a specific question upon Mr. H.J. Sharma, the learned counsel appearing on behalf of the petitioner, as to whether the deed of sale dated 24/7/2007 or even the power of attorney dated 7/3/2007 has been put to challenge by the said by the defendant in the suit, by the defendant in the suit by way of a counterclaim or by any independent suit. The learned counsel appearing on behalf of the petitioner fairly submitted that there is no challenge to the registered deed of sale bearing deed number 9414/07 dated 24/7/2007, as well as the power of attorney dated bearing deed number 1400/07 dated 7/3/2007. This court have duly taken note of that the deed of sale dated 9414/07 dated 24 bearing deed number so and so dated 24/7/2007 was proved not only by the plaintiff witness number 1, but also by the executant, that is the plaintiff witness number 5. Under such circumstances, this court is in conformity with the observations made by the learned First Appellate Court that the deed of sale bearing deed number 9414/07 dated 24/7/2007 was duly proved. This court further finds it relevant to take note of the submission of Mr. H.J. Sharma, the learned counsel, to the effect that the power of attorney did not contain any boundaries. And as such, the deed of sale could not have been executed by the learned by the power of attorney holder in favor of the plaintiff. In the opinion of this court, the said submission is totally misconceived, taking into account that there is no challenge to the deed of sale. Without a challenge to the said deed of sale, the title over the land had duly passed upon the plaintiff. Under such circumstances, in the opinion of this court, the issue number 6 was rightfully decided by the learned First Appellate Court. This court further takes note of that the defendant duly denies the title of the plaintiff and categorically also states that he is not a tenant. Under such circumstances, the plaintiff, on the basis of his title and the defendant having failed to show any better right to remain in possession, The learned first appellate court was justified in declaring the suit in favor of the plaintiff. Accordingly, this court finds no merit in the instant application, for which this court dismisses the instant application. How did you appear, KVA?
Okay.
Otherwise, notice would have been there, you would have got 25,000. However, in the facts of the instant case, this court is not inclined to impose any cost. So, be that as it may, the plaintiffs, the respondents herein shall be otherwise entitled to the cost throughout in the proceedings before the courts below.
So there is the IA application.
For what?
You have not received the copy, but there is an IA application.
I have for stay.
Stay.
Stay has become useless.
This matter also I am praying for adjournment of 2 weeks. I could not contact my client, but it will help.
What?
Why you could not contact the client in a new matter?
I think we may have to withdraw this case, but
Huh?
we may have to withdraw this case.
Better withdraw.
But I need him deal, but I have found but not now.
Tomorrow? You have spent 2 days of this court. 1, 10,000, 10,000, 20,000 cost has gone. Then another 1 day, another 10,000. And there are how many counts? 1, 2, 3, 4. So 10,000 into 4, 40,000, 40,000 into 3, 8, 1,20,000.
They will be kind enough for me the fellow for this.
Huh?
They will be denoted and kind enough to meet of it.
Not you, the appellant.
The villain look.
Cost is 1,20,000.
The next day process.
You don't have a case.
The next day process.
No, nothing doing. Last time also, every time when the matter is reached, you are running away.
Today my situation has also some difficulties. But
What is the difficulty? The case is as regards the three of things. 1.5 or 2. Leho. The counsel for the appellant seeks for an accommodation. It is seen that this court had duly accommodated the counsel for the appellant on 13/3/2024, 10/4/2024. Today also, on the same ground, accommodation is being sought for as regards instructions. It seems that the appellant is not interested in the matter. Under such circumstances, this court adjourns the appeal, sine die, to be listed, sine die. It is further mentioned that this court further makes it clear that this court had not admitted the appeal. And as such, the filing of the appeal shall not be construed in any manner as a bar or a prohibition, as a bar to the decision so rendered, as a bar to giving effect to the decision so rendered by the arbitral tribunal. Yes, what is it?
May I please alert?
Hmm.
So the appellant filed an application under order 21 rule 97/99.
Huh?
The appellant filed an application under order 21 resisting the execution. He was not made a party in the suit, so the decree was passed against another defendant. The execution petition was the application was dismissed filed by the applicant appellant, observing that the appellant may have filed a separate suit, or strangers cannot resist the execution.
Then appeal.
Then appeal preferred same observation was.
My goodness, what is wrong with this court? Are you sure?
Yes, your lordship. Kindly see, lordship.
Yes, what is this?
Yes, Lordship, it is application under order 21, rule 97 and 99 was.
Oh, a stranger has to come.
Yes, Lordship.
Then
Then appeal is now a second appeal, Lordship. Whether second appeal is
second appeal, 100%
Second
because
appeal, my lord.
it's a decree in view of 101, 103.
Lord.
It's a decree. So
Fine.
we frame the substantial question of law in right now way. Give them an opportunity till 2 o'clock in the evening, and then dispose it off again, remitting the matter to the trial court. What do you? You can't get a fast relief like this in you. Frame the question of law. Now, we fix it at 3 o'clock. So by tomorrow, because I can't, without framing the substantial question of law, I can't dispose it. You have to have a frame and give them an opportunity. Tomorrow, let it fix it tomorrow. Tomorrow, yeah. Because you see, it is the stranger who can come. Rightfully, you have come before this court. Where is that order?
Page 55 is the order of the executing court.
55.
50.
Apparently, due to the inadvertence, there is an omission to mention the location of the suit plan in the plane. Being the I found no mention in the number one.
Comparative portion, lordship, 69, lord.
Eight?
69.
Yeah.
1, 2, 3, 4, 5, 6, 7, 8 from 8 line here.
I've heard the submission in the instant case the objector has registered the execution passed in favor of the judgment debtor. Passed in favor of the judgment debtor. What does he write? The judge, page 68.
Judgment debtor, lordship, I am not a judgment debtor.
Read it. Yes, madam, you only read it. Are these type of orders all considered? Paragraph 4.
Yes, sir.
In the instant case, the objector Gopal Ghosh has registered the execution of the decree passed in favor of the judgment debtor
No, Lordship, it
Degree holder.
should be the degree holder, Lordship.
on the ground that the same is a collusive decree and he was a necessary party in the suit filed. The gift deed to which the objector claimed his right does not match with the decretal land, and moreover, the gift deed also mentioned about the existence of a path which was the subject matter of the such suit. The judgment debtors are the nephew of the objector, and all of them have registered the execution of the decree, including the objector. The judgment debtor, along with the objectors, are joint owners of the land, including the decretal land. Further, it appears that the decree holder, though claimed that the plaintiff had managed to obtain the decree. So what is he writing? Isn't the plaintiff the decree holder?
Plaintiff
They
decree holder.
ought to have been.
Write the last 3 lines. Further, it appears that the decree holder, though claimed that the plaintiff has
Managed to obtain the decree in pollution.
but on the contrary, it appears that not only the objector but the judgment debtor and others have registered the execution. Thus, it appears the objector has filed the instance only to delay the exit. The objector could have filed a suit challenging the decree passed in favor of. And let's see who is the great appellate court.
Page 82.
Comparative portion, your lordship, page 91, your lordship. Paragraph 7.
9th of December 2022. 29th of 29/11/2021 is the first one. He's the judge. The instant appeal. This is an appeal under section 100 against the judgment and decree passed dated 9/12/2022, passed in Miss Appeal number 02/2021 by the Court of the learned civil judge Lakhimpur, not Lakhimpur, whereby the appeal filed against a rejection of an application under order 21 rule 97 99 and 101
Status file under
was,
144, not 10.
huh?
144.
What is one?
They have mentioned 144. Read with 144. Yeah.
It's order
144 is what?
97 and 99, read with section 140.
144.
You have been already dispossessed.
No, Lord.
Then how, why 144? 144 is restitution.
Restitution, but
The application that is mentioned 140.
So it is not, yeah, it can't be 144. 144 is for restitution.
yes, it also
Where under 10 yeah,
101.
of the Code of Civil Procedure 1908 was rejected. Was appeal filed by against an order rejecting an application under order here was affirmed. This court admits the instant appeal by formulating the following substantial question of law. Whether the learned courts below were justified in rejecting the application under Order 21, Rule 97 and 101 filed by the appellant and relegating the and with an observation that the appellant ought to have filed a separate suit. Ms. P. but issue notice to the respondent. How many respondents? One?
Only
One,
one.
Lord.
Ms. P. Bhattacharjee, the learned counsel duly represents the respondent. List the matter tomorrow at 2 p.m.
Oblige, Lord.
What judgments you are going to bring tomorrow? Which are the judgments you are going to bring?
Lord, I'll take the
You are arguing an order for 41 Rule 11.
yes, sir.
What is the judgment?
Judgment, Lordship.
Silver line,
Another judgment was there, your Lordship.
Brahma Chaudhary,
Another,
which one? There is another judgment.
yes, your Lord. I'll take. Oblige. I,
You don't need an eye. Tomorrow I'm finishing it off.
oblige.
Yes, Mr. AHMR Chaudhary, what is your ground?
The degree of reversal, my lord.
Ah,
The appellate was plaintiff in the title suit, my lord.
Huh?
Suit was decreed, my lord. But appellate were,
You are a defendant.
no, my lord, plaintiff
Your suit was decreed,
decreed, my lord.
then dismissed.
Then-
Why?
My lord, dismissal was two grounds. One, limitation of limited, my lord. Another, my lord, conjoinder of necessary party. My lord, these two issues were discussed by the learned trial court, my lord. The court to find page 51.
What is your limitation point?
Limitation point according to the appellate court, my lord.
What was the suit for?
For right title interest, that possession as well as cancellation of state deed, my lord.
And?
Cancellation of state deed, my
Okay.
state deed was active.
You wanted recovery of possession.
Oh my, confirmation.
So confirmation is 3. There is no limitation on that. Confirmation of possession, there is no limitation.
But so far cancellation of state deed, my lord.
That is 3 years.
But here, my lord, according to the learned appellate court, it is 12 years. My lord, so according to the learned appellate court, was have been filed within 12 years from 1967, my lord. But it was filed in the year 2005. But
You are the appellant. You are the plaintiff.
But our case is
How 12 years? On the basis of, no, 12 years would have come for recovery of possession.
Yes.
We are not concerned with recovery. It's a case of confirmation of possession. So confirmation of possession, there is no question of any limitation. Is there any limitation? Because when you are there, so you are always there. It is a continuing. Then
About my lord. Page
let's see what are the questions of law you have formulated. Was there a counterclaim?
no man.
Now, what was the stand of the defendant?
State of the defendant is that they were in the date of registration of safety DPR.
And what is the finding?
I think my lord. About my lord.
The vendor of the deed, by accepting the price and vendor handed over the possession to the defendant 30, 40 years back, the defendants have been in possession within this period and the plaintiff did not claim the land. What is the finding as to who is in possession?
My lord,
Who is in possession? Because then your right title interest goes for a 6 again.
my lord, according to me,
No, not you. What is the finding of fact?
text my lord says 51 your lord.
Title suit does it, where is it said who is in possession? Where is the issue?
My lord. Page 47.
You shouldn't. What happened to the written statement? Half it is done. What is why the entire written statement is not here? Mr. Counsel, why page 31, 30? Thereafter, what has happened? Go. Then, what is this type of written statement? Huh? Who is going to type out the affidavit and all these things? I will do. Why the entire written statement is not typed? Not only typed, translated. Huh?
That's very correct.
The learned counsel, Mr. A.H.M.R. Chaudhary, appearing on behalf of the appellant, seeks for an adjournment for 2 weeks. 2 weeks. I won't be there. Let it be an adjournment till 5th of June, so that he can produce the proper translated copy of the written statement.
Can it after after this,
After,
2-3 days after 5th of June, my lord.
well, that's no problem. 10th of, yes,
My lord, the plaintiff filed a suit for recovery of possession and right to the debt, and the defendant has made a counter claim for his suit for specific performance of contract. And the plaintiff put it secret and the counter claim is dismissed. And that's why the plaintiff, this defendant has referred to it, and one evidence is already admitted. And this is on the counter claim part. The substantive question of law is raised under that. 69.
8,
69. So issue is that whether the defendant is entitled for specific performance contract, and it was rejected. It was not.
why do you say it to be perverse?
My lord, because the plaintiff has admitted that he made a contract with the defendant to sell the land, and subsequently it was resigned. Their belief, but it is not resigned. However, the agreement is admitted, but the learned trial court held that the exhibit 4 and 4, which is the agreement, is barred by limitation, and the agreement is not registered. Therefore, the trial court rejected. But the learned appellate court has decided the issue that limitation is there, and the agreement is admissible, but the agreement does not bear the boundary. Only that is why the counterclaimant is not entitled for decree. That was the observation made by Hussain. That contract is admitted. That he willing to sell the land and made a contract. That the consideration of this product of this fruit land.
Now, exhibit co and co,
Huh.
it did make a reference to the original deed of agreement.
That is the deed of agreement. And that agreement is admitted in the plain, my
No, in that agreement, did they say, what does it say in the agreement? What is exhibit co? What is the date?
my lord. 1/8/2024.
Hmm?
And another is 34/30.
No, no, the plaintiff does not say anything about the second deed.
No, my lord.
No, you see the plain. It does not say about the 32/2015 one. 34/2015 in the plain. And mentions about some deed.
Yes, my lord. It is in page 10, my lord.
I've seen it.
Para 6, my lord.
It was read it.
Yes.
Does it say anything about the
The
deed?
plaintiff at present residing at Thing, taking advantage of the plaintiff absence of defendant 1 with the help of his son, relative, and forced the plaintiff land without any rightful interest on or about 2014. The state defendant number 1 approached the plaintiff to sell the land to her, and according to the plaintiff also agreed to sell the land at rupees 4 lakh.
Where is the written statement to the counterclaim?
Yes, my lord. It is
Where is it?
the
You have not enclosed.
yeah, it is here, page 24. Then statement of the
What
Then-
do they say?
yeah.
Here, see paragraph 10, page 25.
Then statement of 20, my lord. It is
Hmm.
at page 24, my lord.
25, 25.
Yes, my lord. Page 10. Then it's two different version, my lord. I am coming. Then the allegation made in para 2, that is the counterclaim, are not actually fully correct. With reference to the allegations made in para 2, this answering plaintiff, OP begged to submit that though initially there was a contract for sale, it is admitted, my lord, of the land for consideration of this 4 lakh. But the contract claimant defendant informed the plaintiff OP that it is not possible for her to pay rupees 4 lakh. So the initial contract was resigned by the contract claimant. The plaintiff stoutly denied that he on 8/2/2014 and 30/4/2015 executed 2 unregistered sale deeds with promise to execute registered sale deed with 2 months by receiving rupees 20,000 in each transaction. That was denied, my
Then
That
it is
is
denied.
my lord. That will go for the trial, and in the trial, it is held that no plea is taken in the trial, my lord. That
It is
is-
there, trial, the plea is there, paragraph number 10. And you, how did you prove it?
so, my lord, he has already admitted that I have made a contract to sell the land, and
But maybe. So
my
is
lord,
is it an oral agreement?
no. It is, my lord, they have denied, but it is an agreement, but that agreement is executed by exhibit co and co, and in that exhibit also, first the trial court held that it is unregistered. The trial court held that. it
No,
is
no, forget about trial court. Trial
Yeah.
court, the first
Then-
appellate court
then-
also.
Then this second, the first appellate court held that the boundary does not contain in the agreement. But admittedly, it is the suit land, my.
Hmm.
Admittedly, it is the suit land. That they have made the contract with the suit land.
You have a copy of the exhibit co and co?
No, my lord, I don't think that.
You get the copy. I'm not satisfied. With this, I'm not satisfied. Mr. TCC Pukon, the learned counsel appearing on behalf of the appellant submits that against the said judgment and decree which have been assailed in the instant proceeding. There is also another appeal which have been filed, another second appeal which have been filed, and the same has been admitted by formulating certain questions of law. By formulating substantial questions of law. Also, the number of the said appeal is
Appeal is RSF 4/2024.
4/2024. List the matter, instant matter along with the said RSA 4/2024 on 10th of June 2024.
But-
In the meantime, the appellant shall also produce the exhibit 4 and 4
Appellate.
photocopy of exhibit 4 and 4 na?
Co and co.
The next.
Item 57.
But email the secretary.
Why?
Please don't like that code number 20.
Huh?
Please that like that code number 20. Like that code number 20.
Yeah, please, Your Lordship. Mr. G. Sharma was supposed to appear for respondent number 1, but he's out of state. So may be taken up some other day.
Monday? Hello?
Can you-
Monday. It has been submitted that the counsel appearing on behalf of the respondent number 1, Mr.
G. Sharma,
T. Sharma. Respondent number?
the number 1.
No, respondent number 1. You are for which bank? No. Respondent number 1 is out of state. Good. On behalf of all the respondents, not respondent number 1, one person has filed for all. What is Mukesh Sharma. G. Sharma. It has been submitted that the council representing the respondent numbers 1A, 1B, 1C, 2 and 2. Mr. G. Sharma is out of town and sought for an committee. Is the matter again on
Can you 5-6?
5-6. Is the matter again on 5-6-2024. Interim order passed earlier shall continue till
Hello.
Wait, little bit.
Hmm.
Sole appellant died on 27/5. And respondent number,
Sole appellant died.
sole appellant. And respondent number 3 and 7.
When?
Giving 27/5/12.
Huh?
Already abated.
There are two appellants.
Memo of appeal only one.
No, two. Abdul Hussain. The two appellants.
Memo of appeal provided to us one appeal. Each case they have made one without any Wakalatnama. Memo of appeal only one. Wakalatnama is also
Only one.
Wakalatnama is also by nature.
Mr. J. Taka, the learned counsel appearing on behalf of the
Respondent number 1, 2, 4, 5, 6, 9, 10, 11, 12.
on
13,
behalf
and
of
14.
some of the respondents submit that the sole appellant had expired long back on 27/5/2012.
And what's respondent number 3 and 7 also expired.
He further submitted that the respondent number 3,
And 7.
7 had also expired.
And the respondent number 8 also expired, and there is an order that appeal is abated against respondent number 8.
3 and 7 had also. It is also seen that no steps have been taken for in that regard. The Learned Council has placed before this court a death report certificate issued by the Secretary Bogwan Kotalbari GP dated 2/10/2020. The same is kept on record and marked with the letter X. In view of the fact that the sole appellant had expired on 27/5/2012 and no steps have been taken, the instant appeal statutorily abates. According to the appeal stands closed.
We are trying to communicate with the applicant.
Huh?
We are trying to communicate with the applicant, not with the people.
We can't help you.
The interim order is there in
Interim order, if any, stands
I will
vacated.
cannot.
The registry shall return the LCR.
obliged.
So, Doctor, I am company secretary and general counsel of the Island Group. So I take your special permission to present it. Like I said.
Tell me.
Your Lordship, I'm like to draw your attention on page number 15 of the petition. Basically, your lordship, this is the 34 order. We are here to challenge this your order, your lordship. The lordship, the difficulty is that this is the Arbitration Act of 1996. When this Act 1996 Act has come, there was the provision and the explanation that if any award is coming by inducement or fraud or corruption, that will be set aside. So, your lordship, it is the Act since 1996. What the mistake Honorable Court has done, they have stated that this amendment has come in 2015. Hence, my petition is. So this is the order, your lordship, page number 15, and this statement have been made, your lordship, in the order on page number 25. So in your lordship, page number 25 says, the lordship,
Yes.
according to the amended law, an arbitral award shall be treated as an award in conflict with the public policy of India, only where making of award was induced or affected by fraud or corruption, etc. So, in the view of the tribunal, this law has come in 2050. Now, it substantiates from the last line. Had it fraud been there in the act prior to institution of the arbitration proceeding has started in 2013, your lordship. The opposite party herein would have been interred to defend such an allegation in the arbitration proceeding, your lordship. Your lordship, we basically I have contested this case in the arbitration proceeding. When the arbitration proceeding had started, we have noticed that some fraudulent documents have been produced before the arbitration. We have quoted this fact before the honorable arbitrator that, your lordship, this gentleman has, what they have done, the demat account of one bank they have taken. They have gone to the Photoshop. Photoshop से ऊपर के portion को, your lordship, they have deleted and previous data को यहाँ paste कर दिया, and they have sent it through the email.
Have you
to
raised that?
substantiate the issue,
Have you raised that issue before the tribunal?
Yes, we have raised this issue before the tribunal, your lordship, but the tribunal has stated over to your lordship, these are the criminal aspects, so you can file the criminal case separately if you like. So, your lordship, what I have done, I have filed the police
If you
complaint.
have you raised that in writing in your objection?
No, your lordship, I have not written in writing, your lordship, I have not written in writing these version, your lordship. Your
I'm
lordship,
not going to listen to all these things, Mr. Petitioner in person.
Yes.
First and foremost, if it is not a part of the record, I'm not going to touch it. Make it very
now,
clear.
your lordship, the basic question what is coming, your lordship, so what
There
we
were
have done.
two avenues available. First was before the arbitrator.
Yes.
Second, there is an appellate arbitrator.
Yes,
There
your
also you did not raise it.
Yes.
You are raising this for the under section 34 for the first time.
No, your lordship, but the bona fide is that, your lordship, we have known that there is a double tier arbitration mechanism. So first award was in my favor, your lordship. In spite of being in my favor, your lordship, I was not knowing whether this will come in my favor or his favor. So the moment we have noticed the fraud documents, your lordship, we have filed the police complaint. And the police has refused to lodge the FIR as the matter was going in arbitration. So I have enclosed the award copy when the matter has reached before the honorable magistrate under 156, your lordship. I have made the argument up to 1 hour before the honorable magistrate, your lordship. And then, on the basis of the entire fact, your lordship, honorable magistrate has referred the matter under 156 for lodging of the FIR. Then the FIR was lodged, your lordship. And now, after the investigation, your lordship, the charge sheet was filed. And here, the respondent is the accused, your lordship. One of the main culprits, your lordship. They are the charge sheeted accused, your lordship. Now, your lordship, my submission is that we have noticed certain fraud. We have the right to file the 34 within 3 months of the award. And 34 subsection 6 says that the 34 has to be decided in any circumstances within 1 year from the date of filing. So the time is 1 year and 3 months, that, your lordship. So in any circumstances in this country, the fraud and inducement cannot be decided and the trial cannot be concluded within 1 year, your lordship. Your lordship, raising the issue in written before the original arbitrator, your lordship, this fact may be correct, your lordship,
But I was a company secretary and law graduate. I was not a practicing lawyer because the lawyers are not allowed in the arbitration proceeding, your lordship. I have never appeared in the court practice as a law. So it was lack of knowledge, your lordship. I have not filed in written these facts, your lordship. But my petition, your lordship, I can present the copy of 156 petition. I can present the copy of the 156 order by which the matter was referred. I can produce the copy of the charge sheet, your lordship. These all things have been done, your lordship. Your lordship, honorable magistrate, is also the legal entity, your lordship. And if we have produced the arbitration copy, award copy, and the entire document, your lordship, which was produced before the arbitration proceeding, your lordship, if the entire documents is forged, if they have made the same settlement, your lordship, let us think that we have not raised this issue before the one arbitrated tribunal, your lordship, in written. It was the advice of the tribunal, but sometime what's happening, your lordship, sometime what we are discussing before the tribunal or sometime before the court also, your lordship, the each and every version are not recorded in the order, your lordship.
Not recorded means first and foremost, you have to raise it by way of your pleading.
Yes.
You have
but-
not raised
yes,
it.
Yes, yes, your lordship.
Mr. Petitioner in person,
Yes,
kindly,
yes, your lordship.
Mr. Petitioner in person, kindly understand two things. First, you filing an FIR has nothing to do with this court. Second, getting an order under 156(3) is nothing to do with this court. Third, filing a charge sheet under 173(8) is nothing to do with this court. It is just an opinion. It is not a finding of fact by a court. So kindly don't make this submission if you don't know law. Listen, you have not raised these issues before the arbitral tribunal. And if you have not raised these issues, don't make these submissions before this court and spoil the time.
Your lordship, but allow me.
No, nothing doing. Section 34 application, for the first time you have come before the court and said, look here, this is an application, it has been induced by fraud on the basis of fraudulent documents. Yes, it is. If it is a fraudulent document, you should have very well said before the court, before the arbitral tribunal. Why didn't you say that? You have not mentioned that. We are not concerned that your company out there did not take the advice of the lawyers, have taken the benefit of the company secretary to appear and who doesn't know the law. We are not bothered with all these things. We are very only expect to be looked out here. In a section 34 is on a very limited score as has been held by the Supreme Court time and again. 37 is also much more circumscribed in that regard. So don't make this type of submissions before the court.
Your lordship, the second submission, your lordship, I like to draw your attention, your lordship, on section 28, subsection 3, your lordship.
What is that?
Your lordship, section 28, subsection 3 says, your lordship, while deciding and making an award, the arbitral tribunal shall, in all cases, take into account the terms of the contract and trade uses applicable to the transactions. So, your lordship, if your lordship will allow me, I can show the first award, your lordship, which was decided in my favor. We have produced the entire record before the arbitral tribunal, and on the basis of the entire records and documents, the award running in 23 pages, they have decided the case in our favor, your lordship, first award. However, when the second award has gone, your lordship, they have taken the law in their hand and they have decided the case as their whims and fancy and as per the trade and uses of the market, your lordship. The main theme for going against the award, your lordship, was their thought that Mr. Kumar placed me the proof of placing of orders, your lordship. At that time, your lordship, the market was opening at 9:30 AM, your lordship, and was continuing till 3:30. So approximately 50,000 clients every day are making the transaction in the entire country. So they were of the view that Mr. Kumar, you should present me the proof of placement of order of 9:30 till 3 o'clock, that how the transactions are being placed by the constituent, your lordship. At that time, your lordship, that law was not there. We have pressed it again and again. So once the trade takes place, we send immediately SMS to them that this transaction has taken place, your lordship. Then we send the contract notes. We send the fiscal contract note. We send the ledger, your lordship. So we have the 5 layers of defense system by which the trade can be decided in our favor, your lordship. And shocking, your lordship, that at that time,
The written law was not there. Your Lordship, the SEBI had started thinking upon this issue, Your Lordship, and in 2018, Your Lordship, 2018, the law has come that now in the market, if you want to place the trade in the system, it should be on the recorded line. And still there is law that if due to some technical failure or something, the broker is not able to produce the voice recordings of placing of orders, then the other documents, the statements, and other evidence has to be taken into the consideration, Your Lordship. Your Lordship, if the law has come into the country with effect from the 1st April 2018 to maintain the proof of placement of orders, Your Lordship, this decision of 2013, Your Lordship, is completely trade practices and uses of the country, Your Lordship. Your Lordship, honestly, this is the case, Your Lordship, and one award has been completely decided in our favor, Your Lordship, and that is running in 23 pages, has captured the entire thing, Your Lordship. If Your Lordship may permit, Your Lordship, Your Lordship, even in the award, Your Lordship, the language clearly, the fraud has not been captured by the Honorable Tribunal, Your Lordship, but the fraudulent contract of the petitioner of that party was recorded, Your Lordship.
Where is the concept of an appellate arbitral tribunal?
It is in the exchange bylaws, Your Lord.
Show me that.
Bylaws. Your Lord, we do not have.
Show me the arbitration clause. Where is the arbitration clause?
It's the statutory arbitration clause.
Where is the arbitration clause?
We are showing, Your Lordship. Your Lordship, can I show you two para? It's very important.
Where?
Page 14,
49. Yes, where?
point number C, Your Lord. This is the first arbitration award, and the fraudulent conduct is reflecting from here, Your Lordship. The applicant himself has contradicted his statement regarding the complaint with respect to updation of the email ID in his account.
Mr. Petitioner in person, kindly appreciate where is the arbitration clause?
Give me- Page 88 for a moment. 88, 5.13A. But they have also not furnished a complete piece of document, but
There is a National Stock Exchange regulation.
But we have produced a copy of the CRF, but
Where?
that photocopy to photocopy that clause is not. We will
First of all, what
we
you
will
want
submit the
to,
copy and exchange bylaws.
Mr. Listen, do you want this court to strike out the response number 2?
Yes. Yes, sir.
We can strike off?
Yes, sir.
You have the authority to say that?
Yes, sir.
How?
I'm the company secretary. I have contested case and I'm authorized by the court.
Where is your authorization? To appear before the court?
Page number 30. Page number 29 and 30.
You are Ashok Kumar
I
Agarwal?
am Suman Kumar.
Huh?
I am Suman Kumar. In the second para, your lordship, Suman Kumar, EPP Corporate Affairs and Company Secretary in court.
Oh, Mr. Suman Kumar.
Yes.
Appear, the company secretary of the appellant company appear before the court today and submit that the name of the respondent number 2 may be struck off. Accordingly, the name of the respondent number 2 is struck off. Mr. Suman Kumar, the company secretary, the appellant is directed to file a memo of party, fresh memo of parties before the registry of this court by 10/5/2024. By showing the name by thereby deleting the name of the respondent number 2. On the basis of the said memo of parties, the registry shall make necessary correction in the cause title and update the same in the CIS. Urgency?
My lord, no, sir.
You have urgency?
My lord, suitable date may be fixed.
When do you want it? There is an interim order.
As per convenience of the court.
Okay, we'll
We
have it
got the
on.
arbitration clause, your lord.
No, you don't give it like this. Hey,
We will fight the exchange bylaws also. And
Next Tuesday, my lord, is possible. Otherwise, it's a covered case, my lord.
No, it is not a covered case because earlier the arbitrator out there had passed the order in favor of you. The appellate tribunal also passed the order in your favor.
Element of
Yes.
fraud, my lord. Lordship has rightly pointed out. This for debt side, but element of fraud, they have raised not to debt from, my lord, it ought to be, my lord. Now, my lord, they are now agreed by the 34 application right now, my lord. Now, 34 for first time it has been introduced about that element of fraud, my lord. So, there, my lord, no doubt, my lord, parties are different,
Hmm.
but the element, my lord, that is the
Now,
fraud.
is the 34 applications only as regards fraud, nothing else?
But that is their pleadings, my lord.
No, is there anything else apart from fraud?
Well, other thing they've raised, but
Yes, sir.
centrally, my lord,
Yes, your lordship. There is
My lord,
any
he-
number of things. I have stated that.
No,
Right.
you cannot say n number of things.
my lord, right now he has argued on the point of fraud. He wants to say that since the
No, it's from point of fraud is negative.
my lord, that's right.
28
Now
million
rest of
He
things,
cannot raise for point of fraud.
my lord.
Point of fraud is
But
gone.
so far the rest
Yes.
issues are concerned, my lord. I think that issue is not because these all are disputed facts, which now right now he's placing this
No,
in that
no.
document.
What other points were raised in 34?
No, my lord, nothing.
Your
Kindly
lordship, both the
see
cases
their
are
grounds, my
different.
lord. Kindly see their
Both the cases are different.
Mr.
Whether
Company
there are-
Secretary, wait. You are not a lawyer. You have to know the decorum. Yes.
grounds, my lord. Kindly
Yeah.
see the-
We'll have it on 21st of May.
Right.
This is the matter on 21st of May. On the said date, the appellant shall bring on record the arbitration clause as well as the regulations pertaining to the National Stock Exchange
Double tier are
in respect to arbitration.
My lord, complete, my lord, petition, my lord, kindly allowed to be furnished, sir.
The appellant is further directed to serve during the course of the day a copy of the entire petition
Right.
to Mr. S.
But in item number 12, I'm appearing for respondent number 326.
Hmm?
I
What is this?
the petition, delay petition. The petition,
Notice upon, you are appealing for respondent.
yes, sir.
Wait. Notice for issue to respondent by raised answer, notice cannot, if not interest cannot be. You are paying for respondent number
326, sir.
326. Okay. None has appeared on behalf of the appellant on call.
Lordship, I have a prayer on behalf of the petitioner. He have contacted me. He is not well. He is in Delhi. So
Don't worry, I won't dismiss for that. None has appeared on behalf of the appellant on call. The record further reveals that the service upon the respondent number one and two is not complete. Mr. Shia Sharma,
she Sharma, Lord.
Shi Sharma appears on behalf of the respondent number 326.
6.
Whatever the 7, 8, and 9.
Their third Lordship. Order
Huh?
dated 6/6/18. Order dated 6/6/18.
You are appearing for 329.
No, 326. 326.
Taking into account the above, list the matter. Taking into account the above, the appellant is directed to take fresh steps upon the respondent number 1 and 2 by register as well as usual within 7 days from today. List of the petitions.
Okay.
You inform
Yes, Lord. Right.
him. Yes, what is this review?
Sir, repeated application was made seeking amendment and amendment was rejected. Amendment was adopted.
You filed for what?
Sir.
13.9. Now, what has happened to the suit?
Yes, there
Any idea?
pending.
Mr. Counsel,
But pending
pending. What is the next state?
EPR perhaps. EPR.
It's still at the stage of issues just being framed. Why such a long whole matter? 5 of 2019.
That perhaps might not recall. Just 2 days earlier, there was a CRP taken by our lordship, and that an application was filed for exception of the stay order granted by this court. Now that CRP was against an application rejecting amendment. So that was again over the same. So this is one review. However, there's another CRP pending. This is going to be discussed. So,
None has
issues are
appeared on
yet to be-
behalf of the review petitioner on call. The record reveals that on the earlier occasion also, none has appeared on behalf of the petitioner on call. So taking into account the above, it will be seen that the petitioner is not interested in the instant proceeding for which the instant petition has dismissed. What are these?
Okay. Both this setup of the matters become infectious.
Which one?
14 and 15.
No, put it back. What is this? RSA? Why?
Initially, the decree has been passed in favor of Gino.
RSA not, no notice has been issued. Nothing has happened.
But it has a matter
Both the cases, confirmation is there and against remand order. Suit is going on, Lord.
Huh?
Suit is going on, Lord. Against remand order.
in the trial was positive proceeded in the midnight.
Against a remand order.
SAO, it should be SAO, Lord. They preferred RS
Okay.
as landlord.
Now
tenant.
what has happened? Suit disposed.
So it is pending at the stage of evidence.
So you don't want to contest. Okay, Mr. D.K. Kolkar, the learned counsel appearing on behalf of the appellant.
Hello.
Does not want to press the interlocutory application being IA Civil 489 of 2019, which is for condonation of delay of 71 days in preparing the accompanying regular second appeal. Taking into account the above, the instant application stands dismissed on withdrawal. The consequential effect is that the accompanying appeal so filed, which is yet to be registered, cannot be entertained, being barred by limitation. So what again? The other one? What is this? This is also same.
Same, Lord.
This is again what you have filed. CRP.
Yes.
CRP for what?
Yes, Your Lordship, the suit is against for eviction notice under
Yeah.
Land Control Act.
Hmm.
That has been remanded back by the largest first April. Against that, because there are two appeal.
Then you have to come under 227 or 115. 115 rightly come. Then you don't want to press.
Yes, sir.
So
Both
that, in fact, that is infructuous. That is not maintainable itself. এই আগৰ order তেনেকে লেখো. Mr. D.K. Kolkar, the learned counsel appearing on behalf of the appellant, submit that the instant application is an application seeking condonation of delay of 71 days in preparing the accompanying appeal against the order dated against the order dated 25/4/2018, passed by the learned civil judge Dhupri in title appeal number 36 of 2015. So, the learned counsel duly submits that the dispute between the parties was a landlord-tenant dispute coming within the ambit of the Assam Urban Area Rent Control Act 1972. Referring to Section 8 of the said Act, the learned counsel submits that referring to Section 8 of the Act of 1972 and reading with and taking into account the provisions of Order 43 Rule 1U, which stipulate that an appeal would only lie against an order of remand provided an appeal lies against that order. The learned counsel submits that the appeal, accompanying appeal so filed, was not maintainable. Under such circumstances, he therefore submits that an accompanying that a revision application have also been filed challenging the same order. The learned counsel therefore submits that he may be permitted to withdraw the instant application. Taking into account the above, the application being ISC 489 of 2019 is dismissed on withdrawal. The consequential effect of withdrawal of the said application is that the accompanying RSA regular second appeal, which is yet to be registered, cannot be entertained as it is part of the This is an application under Section 5 of the Limitation Act for condoning the delay of 97 days in preparing the revision against the order dated 25/4/2018 passed by the learned First Appellate Court in title appeal number 35 of 2015. The learned counsel appearing on behalf of the applicant submits that as the suit is presently proceeding at an advanced stage pursuant to the remand, the applicant would not like to press the instant application. Consequently, the instant application therefore stands closed on withdrawal. The consequential effect of the withdrawal of the instant application is that the accompanying revision application under Section 115 of the Code cannot be entertained, being barred by limitation. I stand.
Apply.
Man appears on behalf of the applicant for the end of justice. The matter can be listed again on 3rd of June 2024 it is made clear that if the applicant is not represented on the next date, the instant application shall be dismissed or not. None has appeared on behalf of the applicant. All the court have duly taken note of the affidavit filed by the additional affidavit filed by the applicant as regards affecting justice service. The state affidavit does not mention anything as to how and when the justice service was affected upon the sole respondent. Under such circumstances, the petitioner hearing, the applicant hearing is directed to take such steps by way of justice rooted to the registry of this court and file an affidavit of service on or before the next date. List the matter again on 17th of July 2024. Hmm.
And the office teacher 24. Agriculture research. Short research. At this
Yes, madam, you effect service by way of justice. It is not done as per this. The signatures are illegible. You can't help it. Or you want to take first step? Dusty will be quicker. You want it to be. This court have duly taken note of the office note dated 3/5/2024, which states that the ID card of the respondent numbers 1 to 4 have been received with some illegible signature on each card. So this court, taking into account the above, direct the applicant to take steps upon the respondent numbers 1 to 5 by way of
1
the
to 4.
1 to 4 by way of the state rooted to the registry of this court and file an affidavit of service on or before the next stage. List the matter again on 19th of July 2024.
my lord,
You are appearing for the respondents? IA for what?
this my lord, CIM, 4250, my lord, for continuance of delay.
How much?
My lord, for 7 years, about 9
Uh-huh.
months, 7 years,
Why?
9 months, 28 days.
Why?
Because lordship, this is for setting aside the abatement and to bring the record of alert.
No. Why?
Because my
Why
lord,
7 years?
because we came to know when they filed affidavit, my lord, that page 17, annexure 2. Earlier, my lord, I prefer one revision, that is 209, against the execution. Now, in that revision, my lord, they file affidavit, respondent, and sole respondent Abdul Gafur demise, my lord, on my lord, 7/10/2000. I came to know, and court, my lord, observed that the RSA have already been abated. Therefore, the court observed that appropriate action is to be filed. So, setting aside the abatement, because the respondent, sole respondent, when that RSA cannot be survived. Therefore, my lord, the RSA will dispose of, but that cannot be, my lord, survived. Because sole respondent in the petition prior to pass judgment. So, the court observed that matter already been abated. So, the process of abatement, therefore, this continuation and lordship, so far, IS 4251 is concerned, my lord, this is sufficient, the legal here, and IA 4252 is the
So
setting
what is
aside.
your ground?
Ground, my lord, because
You are saying many things. What is your ground?
ground, my lord, we came to know that after receiving this affidavit in reply, and therefore, my lord, this honorable court passed order in case, my lord, 14,
Ah.
saying that as matter already been abated, so needless to say, case 16, the petitioner at liberty to file any appropriate application if so advised.
Then?
So therefore, my lord,
Who died? Sole appellant.
sole respondent.
Sole respondent. And was the respondent appearing, the counsel for the respondent appearing before the court in that RSA
Yes,
on
lord.
2011?
I have narrated.
Now your narration won't do. What does the records do?
Or on the page of record, I have
Was the respondent representing all along?
on record, my lord, advocate for Abdul Gafur, Mr. A.K. Ali, and
A. Algamid.
record reveal, which, my lord, also suppressed by the present counsel affidavit. In the present affidavit in reply, in my earlier
Now what is this IA Civil 430/2008?
430, my lord, 2000, it's for substitution.
Why did you withdraw?
Substitution, withdraw, my lord, honorable court says that as RSA itself abated. So process of abatement is to be set aside. Without setting aside the abatement, the court cannot substitute. This is the case. Therefore, I prefer this application. This is my
You
lord.
are appearing for whom, Mr. Counsel?
What, my lord? For one.
Who is respondent?
This is the
All these. One I, 2, 3. All these. You are paying for all.
my
1A to 1I.
all.
You are going to file an objection.
My lord, what happened? The both the parties are from the same meeting. So question of suppression, that date was the question of the suppression of the date.
So why don't you file an objection? File an objection. It will be easier for me to dismiss his petition.
Type it.
So we dismiss this IA, then all others goes for a 6. File an objection. Mr. So-and-so appearing on behalf of the opposite party number 1A to 1I submits that he would like to file an objection to the application seeking condonation of delay. Lists the matter again on 17th of July 2024. The affidavit be filed by 15th of July.
If there is a stay order. that's it.
Huh?
There is a stay order, my lord.
Stay for what?
29/12/2021.
Stay for what?
Stay for execution.
How can there be a stay for execution?
No, there is the order.
Mr. Bhuya, only to
No, no,
those if there is a stay, tell the executing court the judge must have forgotten to include. But don't court ask this court. If you say, I will say that the question of granting extending a stay does not arise in respect to an abated appeal. As of now, the appeal is not there. Tell me,
But-
as of now, is the appeal there?
But order passed
Wrongly passed.
29/12.
Absolutely wrongly passed. First, there has to be an appeal. Is the appeal there?
Right, that's right. There is a stay order.
Huh?
There is a stay order.
So I vacate it. Wrongly passed.
But
Should I mention that?
But stay vacating.
Not necessary. In fact, that order is passed without being conceived. Because you see, you need to pass in something. As of now, there is nothing. You don't have the second appeal.
My lord, when RSA tell appetit. Now,
Once it
now
abates,
detail here not on record.
not on record. So,
Therefore, I pray to bring them on record.
so understood.
So
As
until
of now,
that,
Mr. Bhuya, as of now, the question is whether this court is going to condone the delay of 7 years. One. After condoning the delay, I have to set aside an abatement. After setting aside the abatement, I will set in plea the legal representative. Now, against whom should I pass the status quo? Tell me. So therefore, whoever passed that order, it's completely misconceived order. You can't pass an order against a person who is not there. As of now, it is against a dead person. Can you pass an order? Next. Click here. 20. No justice service.
Milo.
According the appellant is hereby except for Yes, tell me.
Dot is, as for October dated 1/5/24, we have not taken space through justice service because from 1996 they are staying separately, and now it is not possible for to go in front of the respondent.
Huh?
And now it is not possible for the petitioner to go and serve by hand to the respondent. So kindly grant us to take steps through usual process
No, tell me why.
because they are staying separately from 1996, and they have already moved on to their life.
You have?
They have already moved on.
What is this mat appeal? Who has asked you to ask that person to go and serve it?
In justice service,
Justice service is to be done by any person. Any person can do who takes it and then files an affidavit. Then look here, on the basis of instructions, I have daily taken it and then I have gone and given it to him. That's all. And thereupon that person needs to file an affidavit. That's all. You can very well go to Calcutta if you want, or you can ask your clerk to go to Calcutta if he wants. Calcutta, weather is good, go there. Take justice service. Okay. The learned Ms. R. Saha, the learned counsel appearing on behalf of the appellant submits that in view of the fact that there was no date fixed in the order dated 2/6/2023, the justice service could not be affected upon the sole respondent. She, however, submits that the appellant would duly take the justice service routed through the registry of this court and file an affidavit of service. List the matter again on 22nd of July 2024. Gustav. the appellant is directed to take effect justice service upon the respondent routed through the registry of this court and file an affidavit of service on or before the next date. Full stop. It is relevant to mention that the appellant need not personally go to effect the justice service. The appellant may engage any other person. However, that person who effects the justice service is required to file an affidavit.
Matrimonial appeal method.
Yes, mediation done.
The mediation failed. On first day, the appellant appeared, my lord. And on the second day, he had an infection in his leg. He could not come. There is a report.
This court have perused the mediation report dated 21/2024. And from the mediation report, it reveals that the mediation has failed. The court have also taken note of the LCR having been received and the respondents are duly represented and the respondent is represented. Accordingly, this is the appeal for hearing in its usual court. Parties are therefore, however, given the liberty to mention the matter, is given the liberty to file applications for early listing. If so advised.
Obliged.
So that matter, how much is the delay?
Fine, fine.
Has the other side appeared?
But if I don't have the brief.
The Miss, your name?
So
So and so appearing on behalf of the applicant submits that taking into account the office note dated 29/4/2024, some time may be given to the applicant to take appropriate steps. List the matter after 6 weeks. Madam, look at this office note. Some other people have died.
One 157 days.
Round.
Crown, my lord, he was only 2 crowns he has stated, my lord, in his application, my lord. By wrongly, his case was registered as a civil division, but it should be FAO. And after that, he went to Chandigarh. I'll object the time for the vote is certain.
Arbitration case was missed for default.
Yes, ma'am.
None has appeared on behalf of the applicant on both. What is this additional affidavit?
My lord, that's wrongly, that is objection.
Additional object.
No, additional, no, only objection, my lord, that's wrongly.
From a perusal of the state application, it is seen application for condonation of delay, it is seen that the applicant had filed an application challenging the order dated 6/6/2018, which was registered as, which was had filed a civil revision application challenging the order dated 6/6/2018 and a filing number being CRP 7690/2018 was allotted. Thereupon, it was on account of advised that it was that first appeal against order ought to have been filed. The said application was withdrawn and the accompanying first appeal against order was filed. The registry shall verify the said aspect of the matter and place an update before this court as to whether any civil revision petition bearing CRP filing number CRP 7690/2018 was allotted against to the applicant to list the matter again on 10th of June 2015. Yes, service is not complete.
Now take step on correct presented.
Mr. So-and-so, the learned counsel appearing on behalf of the applicant submits that he may be permitted to take fresh steps upon the respond numbers 1 to 4. So taking into account, he is directed to take steps by way of registered as well as usual within 7 days. It's the matter of the completion of service.
It present corrected.
Right.
Apply.
Yes, what is this? Huh? LCR received. You are appearing.
I filed an affidavit in reply to their affidavit, additional affidavit. That is not brought on record, my lord. It was filed in the month of November.
The appeal have the service being complete and the LCR having been received. This is the matter for hearing in its usual court. Liberty is given to the parties to file application for early listing of the matter, early hearing of the matter.
Please, the Lord. Okay, as per office note dated 25/4/24, it appears that the respondent number 6 and 7 has expired.
6, 7, 11, and 13.
11 and 13, as per our information, they are alive. Why this thing has come, I do not know. But we need to make track steps on 11 and 13
Mr.
and file a substitute
Because
petition.
the learned counsel appearing on behalf of
And,
the
on
applicant
7.
submits that in view of the office note dated
25/4/20.
25/4/2024, he would require to take some steps which
On
accordingly
11
matters
and
can be
13,
shown to be
And
listed after
substitute application in 7.
2 months.
Okay.
this case has only been completed.
Service complete?
Yes.
Okay. Now
I
let's
got
see.
it.
What is the matter about?
Matter is also the TB division has filed matter to for pushing the further proceeding of the execution, title execution.
Huh?
That one. Execution case matter. In
What?
this case matter, what happened to Lordship?
Where is the impugn order?
Your Lordship is kindly Annexure 7, page 136. The order was passed in title execution.
136, page,
Page
which order?
136. Yes,
Which order?
136.
Which order you are challenging?
We are order posting, harder posting of.
You are challenging the entire execution
Yes.
proceeding. Why?
Because in this case, the title suit was filed by the plaintiff. After receiving notice, defendant engaged a counsel. The engaged counsel only filed the Okalatnama and affidavit. However, the copy of the affidavit did not furnish to the plaintiff. Accordingly, learned trial court exclude the written statement from the record. That appears on record.
Then,
Thereafter, my lord, in the evidence, it states, my lord, the learned counsel for the defendant did not make appearance in the cross-examination. Therefore, cross-examination was closed.
then,
Thereafter, my lord, title suit has been proceeded and judgment and decree was passed.
then,
Thereafter, title execution case was filed by the plaintiff for execution of the ejection of the house, my lord, and giving position of the house to the plaintiff.
then,
Thereafter, my lord, on 8/10/2021, civil Nazir went to the place of the premises. Then the my lord, the present prisoner came to know that the title suit has been already
then,
dead.
thereafter,
My lord, the suit premises was vacated. The position was given to the defendant. He rushed to the trial court. Then he came to know that the execution case is pending for the realizing the decretal amount for the payment of the decretal amount. There is area of rent amount.
then,
So immediately he made an application to the trial court, my lord, stating the fact that, my lord, the learned trial engaged counsel did not
which order?
furnish.
Which order is passed by the learned executing court?
Put it on. Page 135 page.
Then, where is your application?
Application page 132, Annexure 6. The application was filed by the defendant engaging a new counsel, my lord.
Why are you aggrieved?
Now, my lord, the learned trial court has fixed the date for payment of the arrear amount, my lord.
Fantastic. Then,
We
why
are
are you
ready to
aggrieved?
pay, ready to pay.
No, but the counsel, one thing tell me, when a judgment and decree is passed, what will the executing court do? What will it? Execute the decree?
Yes.
Can the executing court say that look here, the judgment is wrong because the counsel of the defendant had done some mischief? No. So why you are challenging here? Have you filed an appeal against
my
the
lord.
judgment?
No, appeal was not filed because he was totally unaware about
Understood, but why you are not filing an appeal against that with a condonation application? What is all these things?
Immediately, my lord, when he came to know about the execution case for recovery of the payment, my lord, he
So what to do? Dismiss
No,
or withdraw? There is nothing else. There are two options. Either dismiss or withdraw. Which one? Well, nothing more.
no, what may I make much of?
No.
Kindly come to paragraph 14 of my.
What?
Kindly paragraph 14.
Mr. Counsel,
May
I
continue?
accept everything what you say. Let us assume that your lawyer who was there for the defendant had played the mitch. Let us assume that he even colluded with the plaintiff counsel. Absolutely. Then can the executing court set aside a decree and hold it non-est? No. Only way is to file an appeal. Why you are not advising your client to do that instead of moving this application, keeping it pending from 2022? Tomorrow another lawyer will come up and say, what's your name?
R.
R.
Hussain.
R. Hussain. Have also not done it properly. He should have advised for filing an appeal there rather than filing all these type of applications. Another lawyer will come. Better file an appeal. What are you doing with all these things?
We would we'll highlight.
If I was sitting out there in the appellate court, I would have asked you without condonation. But I am not. I am here. Go and file an appeal.
Yes. That you may be allowed.
Mr. R. Hussain, the learned counsel appearing on behalf of the petitioner, submits that the petitioner would be better advised to file an appeal against the judgment that dated
1/11/2009.
1/11/2019. Passed in docket number 354 of the 2019. And as such, he would withdraw the instant. He, however, submitted that the withdrawal of the instant petition should not prejudice the petitioner to pay such other remedies as available. Taking into account the above, the instant petitions that close on withdrawal. The withdrawal of the instant petition shall not preclude the petitioner to evade such remedies available.
Keep all right.
Yes, what is this? RSA?
There is a delay petition,
How much?
496 days. Second appeal. Already. Second appeal was already admitted. However, the second
That's the
appeal
limitation act. What? Second appeal, why?
because we instituted the suit as against the suit, they filed their place and the counterclaim. They preferred only one appeal, and they set aside the trial court, the appellate court set aside our decree, but counterclaim was decreed. So therefore, our appeal second appeal was against that setting aside decree. Thereafter, after limitation petition, we have filed a second appeal as against the counterclaim.
What about service?
Service has been carried out. That is why it was taken along with the other second appeal. Because the address which has been given in the same
Who is appearing for the other side?
Mr. Dubey.
Ready. Not there.
Name has been shown. Positive name has been shown. We wanted to take the service to the advocate.
In this appeal, who is the appellant? Other appeal.
Other appeal, we are the appellant. We are the original plaintiff.
You were the appellant.
We are the
In
plaintiff.
the other appeal also.
Other appeal, we are the appeal.
There Mr. J. Roy is appearing. Now you are
Lord.
there Mr. Dubey was appearing.
Yes, he was appearing. It was highly contesting. Two IA has been filed.
The respondents have not appeared for a long time.
I don't know.
Their name has been shown.
Yes.
Take it. You take first step, Mr. Bhagwati,
Sure,
can't
Chief.
help.
Only thing we may be allowed
Well,
to take active service because
Yeah. The PPK Bhagwati, the list of the theory, take back up the system, maybe it is not the application,
Lordship.
maybe given the deputy, take step by way of the state upon the
1, 2, and 3.
one is okay, others are performer.
Others are performance,
Upon
but he contested finally joint.
Huh?
He contested 2, 3 contested by filing joint detention.
120 joint
Lordship.
120 to take it above. It court director fixes the instant matter on 22nd of July 2024. So the petitioner is direct, the applicant is directed to check the sticker on the 120 by way of routed to the registry by app.
As per the office, last office report, office has not been charged. So Lordship, we may be allowed to take it. Yes.
The office note dated 3/5/2024, it is the service of 5. Court have really taken note of the service that steps were taken and notice was issued on 14th of the such substance that the applicant hearing is directed to applicant hearing is directed to effect to take step by register as well as usual. I list the matter.
Obliged.
How many respondents are there?
2 respondents.
Has been received.
80 received. As per
This application for 15 days. So this is an application filed under section 5 the Division Act 93 for controlling the delay of 16 days, preparing the connected second appeal against the judgment dated (15 to 2022) in money appeal one of the court have perused the grounds that have been mentioned that the application, particularly paragraph number 8, 9, 10, and is of the opinion that the state constitutes a sufficient cause for condoning the delay of 16 days in preparing the accompanying second appeal. Accordingly, the delay of 16 days is condoned. I stand allowed. The registry is directed to register the accompanying second appeal and list the matter for in the column of Order 41 Rule 11 on 10th of June 2024. I
Obliged.
service upon the respondent number 243451 to 5554 and 6 is not complete. It's the matter.
Seeking transfer of-
Appearing,
I am for the your sole responsibility.
where do you want to go? Where do you want to go? It's a transfer matter.
From Haflong to Korimoj.
Upon to
Korimoj.
so to Korea.
Yes.
Guardianship matter.
Yes, custody of the thing.
Who are you?
Yes.
Who are you?
I am the wife, the mother of the secret.
It is with whom?
My lord,
Child is with whom?
with me, ma'am. I have filed petition for custody, your lord. Yes.
Understood. But how can you file it there in view of section 9?
Your lordship, I'll file my affidavit, your
It's
lordship.
not necessary. Why do you want to spoil your time and
Okay.
energy?
I need to bring some recording.
What do you want to bring on
Your
record?
lordship, the childs were your lordship. We had been living there, your lordship. They were studying there, your lordship.
Now, where is the child reside?
They're with mother.
How can you? It has to be where the child resides, isn't it?
But it is the better place for them, your lordship.
Where?
They are in Dimahatur.
Understood. Get the guardianship, bring the child to Dimahato, live there. But for fighting the litigation, go to Karim.
Your lordship, I will be given an opportunity, your lordship. Just your lordship, I file it. By tomorrow, I'll be filing it, your lordship.
Eh?
Prepared. By tomorrow, I'll be filing it. After any
The learned counsel appearing on behalf of the respondent submit that by tomorrow he is going to file the objection to the instant application. So list the matter again on 17th of May. Today's what? 17th of May,
My lord,
2024. Interim order passed by Leshil.
my lord, I have one prayer, ma'am.
Who are you?
I am Mr. H.R. Sutri, and I am Mr. H.R. Sutri, and my junior's name is Talukar is shown as an engaged counsel for respondent. However, I have not found any color.
Go to the registry, tell the registry.
Yeah, please, your lordship.
Yes, what is this
appear-
case? Where's the other side?
Lordship, we have filed a wakalatnama yesterday. So we request some time to file the.
Why do you require so much time, madam? What order is he challenging? Tell me. Maybe
Senior is engaged in this matter.
you become the
Not-
senior.
Actually, his mother is in hospital. So the brief.
I'm ready to dismiss this petition. You have a problem.
We request some time, lordship,
For what?
for filing our affidavit.
Why do you need? When I'm dismissing his petition, you are the respondent. None appears on behalf of the petitioner on call.
Action.
Lorenzo appears on behalf of the respondent. Is an application under Article 227 of the Constitution challenging the order dated 15/3/2023 passed by the learned court of the Munsif number 1, Kamrup Metro, Guwahati, in Mirze case number 322 of 2022, arising out of title execution number 23 of 2017. This court have perused the order dated 15/3/2023, which have been impugned in the instant proceeding. From a perusal of the state order, it reveals that the petitioner herein had filed an application under Order 21, Rule 29, read with Section 151 and Section 47, seeking stay of the execution proceeding pending disposal of title suit number 43/2022, along with Ms. case number 39/2022. It is apparent from the materials on record that the decree which have been put to execution is a judgment and decree passed in title suit number 49/2012. This court have duly perused the applications so filed under Section 47, read with Order 21, Rule 29, read with Section 151 of the Code of Civil Procedure 1908. By the said application, the petitioner herein sought for stay of the further proceedings of the execution case till the decision in title suit number 43/2022 and Ms. case number 39/2022 in between the decree holder and the judgment debtor in respect to the same property. This court finds it very pertinent to take note of that the execution proceeding being titled execution case number 23/2017 arises out of a judgment and decree dated 4/8/2014 passed in title suit number 49/2012, whereby the learned trial court dismissed the suit of the plaintiff and the counterclaim of the defendant was decreed, declaring that the defendant has right title, interest, and possession over the scheduled land of the counterclaim. It was also mentioned that the defendant was entitled for recovery of past possession of the scheduled property of the counterclaim by evicting the plaintiff and his men. Against the said decree so passed, judgment and decree so passed on 4/8/2014 in title suit number 49/2012. A title appeal was filed by the plaintiff of title suit number 49/2012, who is also the petitioner herein. The said title appeal was registered and numbered as title appeal number 78 of 2014. By the judgment and decree dated 27/5/2016, the said title appeal was dismissed. It is under such circumstances the execution application has been filed. Therefore, after the execution application has been filed and almost after 5 years thereafter, the title suit number 43 of 2022 has been filed by the plaintiff of title suit number 49 of 2012. Seeking declaration and permanent injunction. In respect to the subject matter of the same suit, which was the subject matter of the counterclaim filed by the defendant in title suit number 49 of 2012. Along with the said application, an injunction application was filed, which was registered and numbered as Misde case number 39 of 2022, seeking a temporary injunction restraining the defendant therein, the respondent herein, from entering into the suit land till the disposal of the suit. This court have also perused the said application to file, on the basis of which the order dated, the impugned order dated 15/3/2023 is passed. In the opinion of this court, the order dated 15/3/2023 has been passed by duly taking into account the relevant provisions of law as well as the well-settled principles of law. The question of staying the execution of the decree passed in title suit number 49 of 2012 does not arise in the facts of the instant case, and as such, the learned first executing court have rightly dismissed the said application. Consequently, this court finds no reason for interfering with the impugned order, for which the instant order stands dismissed. The instant petition stands dismissed. Yes, what is this?
Lordship, the plaintiff instituted a suit. Defendant appeared file the players and counterclaim. As against the counterclaim, we could not file our against section within time. and that was displayed out. London trial court did not allow us on 2 occasions.
Huh? Where is that order?
Order at 48, page 48. 48. Peru's court says represented Peru's the case record today is the day fixed for objection or counter claim by the plaintiff. Seen the petition filed by the learned counsel, the plaintiff praying for another date to submit the same, showing the cause of lack of some necessary documents. Third, Peru's this seen that date of petition.
What necessary document?
I don't know.
Huh?
I don't know.
Then isn't it a frivolous excuse? It's absolutely, if you don't know, no, you can't take it for granted. The fact that you don't know what is the necessary, this on the face of it,
Because
you are asking, you are taking the court for a ride
Lordship, my
and then spoiling the time of the court. by
my
filing
humble
this
submission, at
petition.
least that lady should be allowed to at least substantiate her if she has any-
No, nothing doing. If you make this type of submission out there that another stuff is necessary document, what is this necessary document? Why didn't you file your objection to the counterclaim?
May I, Your Lordship? I'm appearing on behalf of respondent number 153. Now, the failure to file written statement against counterclaim, Your Lordship, rightly incorporated in order 86A to 6Z, Your Lordship. Now, 6Z says, Your Lordship, all the rule and provision of written statement will be applicable against the written statement of counterclaim, Your Lordship. If it is so, Your Lordship, then the limitation will be within 90 days, Your Lordship. I have filed the counterclaim, Your Lordship, on 7/9/2022. Now, Your Lordship, 20 December 2022, it is the date when the statutory limitation has already been expired, Your Lordship. The statutory limitation, that is 90 days, already been expired. Your Lordship. On 8/12/2022, it has already been expired. Your Lordship. Then, Your Lordship,
Madam, do you want me to allow his application?
no, Lordship.
Don't make that submission. Yes.
I was asked to pay 700 cost that I have paid.
Huh?
I was asked to pay 700 cost that was paid. So I
Why
paid.
didn't you file it? What is this necessary document? If you don't know, you are making a false statement before the court.
Maybe actually there was a two unregistered documents. Unregistered documents were there.
What is that?
Unregistered documents of agreement between the
Dated?
parties.
Dated?
Dated actually that they claim in the WS they have to claim that there was another agreement between the parties. So she wanted to know whether there is any document or not.
She wanted to know about that document or not when the written statement was filed. Does it take 90 days for that?
Maybe because of that.
Have you mentioned in your petition about that document?
No, not.
That dismiss it on-
No, see, at least only thing, let her also justify her case. If she could not prove her the claim, then her case she automatically
1 lakh.
fail.
Say I have not given anybody. Because this is absolutely incorrect.
I also believe it that actually it was not a very good case. But only thing, being a lady and she was having some problem, medical problem, that may be considered.
What?
So we have given medical certificate.
But you want the medical certificate as a necessary document?
No,
That
no.
was not the ground
No,
before
why
the
she
trial
could
court.
not- Why she could not do it within the time of specific time? She explained it that she had some problem. Medical documents are
You
given.
said about no, we wanted a necessary.
As an advocate here, I may not be able to tell exactly what was the necessary document. It was the advocate who conducted the case on behalf of her. May she
Who was
may-
the advocate?
no.
Ask him to pay that one.
It will be heavy one.
Nothing is to be done.
No,
Go
with the 700 and 1 lakh, it is very heavy amount. Maybe a limited amount may cost.
Go to the- and-
Then that case, I'll take instruction on that part.
Yes, madam, do you have the order 8 TPC with you or not?
Yes, 6, yeah.
Let's see what is your. What do you say?
Yes, Your Lordship, order 86Z, Your Lordship. The rules relating to written statement to apply, Your Lordship.
Order 8, Rule 6,
Z,
D,
Z, Your Lordship.
C.
No, G for Guwahati, Your Lordship.
G. Okay.
Z, Your
Yes.
Your Lordship, rules relating to written statement to apply. Your Lordship. The rules relating to a written statement by defendant shall apply to a written statement filed in answer to a counterclaim.
Okay.
Now, if
Now, what do you say about Order 82683?
yes, that the provision is there, Your Lordship, but
How
six-
do you take care of that? When the plaintiff shall be at liberty to file a written statement in answer to the counterclaim of the defendant within such period as may be fixed by the court.
yes, Your Lordship. But on the other hand, you have to this.
Whereas the bar under Order 8, you see the rules as regards filing of the AR would be different. But when the provision out here categorically gives the court the other discretion or the plaintiff to file anything else, how do you apply Order 8, Rule 1 to apply here? There's no embargo out here, unlike in Order 8, Rule 1. 8 Rule 1, it says about 90 days. Is that your answer? That is why I said, why do you make your argument? 1 lakh.
It will be very difficult.
Okay, think about it.
Listen, better be, I'll take offline inspection regarding the necessary document.
No. You take the instruction about 1 lakh. Who is going
1 lakh, I don't know, 1 lakh. It was only 700 before the trial court. 1 lakh it will be too heavy. The total amount is say, around 7 to 8 lakh.
to them up? Is
7 lakh.
7 lakh for what?
There was some vehicle, Polaroid vehicle, which the person defendant took it on rent. There was an agreement. They claimed that they wanted to purchase, they got it purchased, sold it, and we refused to execute the sale deed in respect of that. That was only the thing. The
The
lady,
suit was for specific purpose.
This
suit for
cancellation of the
injunction,
deed,
suit
Your
for
Lordship.
injunction,
For cancellation of the sale deed. The sale
And
deed.
sale
what is the
agreement.
counterclaim for?
Sale agreement, they claim that we have subsequently another sale agreement between the parties. They
What is
wanted
the
to
counterclaim for?
counterclaim for effecting that subsequent sale agreement. What is the agreement between the parties?
So it's for specific performance. That is what I said.
All right, not it. That is, amount is very limited amount. I don't think by this time depreciation has also gone. It may not be of the 7 to 8 lakh now. It will come down there to 3 to 4 lakh. So 1 lakh will be too heavy amount for everybody. I at least to that extent I may be given time so
25,000.
that I can get it.
25,000.
It's actual option on that. 25, I don't know even we got that 25 or not. I don't know. I don't know if we got that 25,000 for that.
Then very well. Don't execute the decree. Whenever the counterclaim is decreed, don't execute. If you don't have it, go to the civil prison.
I will be another day so that I can come with that 25,000 or something.
The instant application has been filed. Challenging the order dated 2012-2022, last time to 4A of 2022. In that the whereby the learned court of the Munsif
Kalia vote.
Kulia had rejected the petition, taking time for filing the written statement against the applicant on the ground that on the earlier occasion, last chance was granted with the liberty, with a further direction to pay deposit and cost. Then also, the written statement was filed of the claim. This court had perused the state order and there is a reference to a petition number 947, which was the petition filed by the petitioner. And the ground taken therein is lack of some necessary document. This court had asked Mr. B.K. Bhagavati, the learned counsel appearing on behalf of the petitioner, as to what is the necessary document. To the surprise of this court, the counsel is not aware of what was the necessary document on the basis of which the said petition was filed. This court is, however, not satisfied with the he, however, submits that he would like to take instructions in that regard. List the matter after did stay, no stay. What is going on?
Going
What is the state?
Going on.
What is the stage of the suit?
As against defendant number
Because-
4, service is not completed yet.
Yes,
Huh?
As against defendant number 4, service is not yet completed.
is it?
Only that is going on.
That is good.
Let them file the written statement. Cost of 25. It's the matter again on 5th of June. Yes, what is this?
Lord, wife has filed an application for directing the husband to meet their daughter at a public place.
Who?
To meet their daughter, minor daughter,
Ah.
at a public place, which was rejected by the Karnataka court.
Why?
That misconceived the unfair without pleading of the party.
Without
Yes, that is
Uh,
without a page 43.
You are who?
I am wife,
Mother.
mother.
The child is who? The husband.
Both.
Huh?
Child has gone out of their wedlock, which was challenged
Child is with whom? Child is with whom?
for mother,
With you?
Yes.
Then who has filed that application?
myself,
For what?
for meeting the child at a public place.
The child is with
Because
you.
The child is growing up and seeking for her father.
Oh, that is what.
Yes,
And the father doesn't want to meet.
Yes, he too wants to meet.
Then why was he rejected?
Yes, that is why I got. He misunderstood the pleading of the parties.
Testimonial cases are going on. This lady has filed 2 different cases of divorce with 2 husbands at a time. I am the second one. So my marriage is nullity. Now I am interested to meet my daughter, but I am afraid of my wife. Therefore, I am avoiding. Now she is insisting anyhow you come and meet at some place so that I can create some acrimonious situation, file some FIRs against you and harass me further. I am
No, no,
totally
no,
reluctant at this
no.
stage, my lord.
Okay, one thing can be done. It can be, after all, you admit the child is yours?
Yes.
Now, therefore, meet in the family court or in the court premises.
There is no. But apart from that, if she asks for any other place, my lord, we have
No, don't go
education.
for other places. It's a family court or what court? District judge. Huh? Meet it in the office of the district judge.
No.
I will do one thing. You withdraw the petition. Yeah. I give you the liberty and give you a liberty of filing application. And he says that he has no objection in meeting in the premises of the And then I direct the authorities to the district judge to consider that and pass on. Better.
Now withdraw.
You see what order I have. This is an application under Article 227 of the Constitution challenging the order dated 31/8/2023, passed in Measles case number 39/2022, whereby the application filed by the petitioner, being petition number 537/2022, was rejected by the learned district judge, Punitpur Tejpur. This court had perused the said application, which have been filed by the petitioner before the learned district judge. From a perusal of the said application, it revealed that the petitioner herein, being the wife who has the custody of the child, wants that the child should also meet the father, and as such, filed the application so that the father, so that a direction be issued to the father to meet the child at a convenient place. This application was rejected by the learned district judge, Punitpur, on the ground that the husband, that is the father, did not voluntarily desire or want to meet the baby daughter as demanded by the wife due to their matrimonial discord and distrust. I've heard Mr. S. Sahu, the learned counsel, appearing on behalf of the petitioner, and Mr. S.K. Singh, the learned counsel, senior counsel, assisted by Mr. Soento, appearing on behalf of the respondent. This court had put a specific query upon Mr. S.K. Singh, the learned counsel, senior counsel, as to whether the respondent herein, that is the father, would like to meet the child. The learned senior counsel submit that the father duly wants to meet the child, but however, fear that if any direction is passed to the petitioner upon the respondent to meet the child at any other place, the petitioner herein would cause matrimonial discord and discord in the public place, so that further cases can be filed against the respondent. This court is of the opinion that for the benefit of the child, the parental guidance of both the mother and the father are equally important. Under such circumstances, this court closes the instant petition and grants the liberty to the petitioner herein to file an application before the learned district judge, Punitpur. In view of this liberty is being granted, taking into account the submission of Mr. S.K. Singh, the learned senior counsel, appearing on behalf of the respondents, that the respondent has is also inclined to meet the father, meet his daughter. However, in such a circumstances, if such an application in the circumstance an application is filed by the petitioner before the learned district judge, before the learned district judge, Punitpur, it would be within the jurisdiction of the learned district judge to permit the respondent herein, who is the father, to meet the baby daughter within the complex of the district court with above the instant petition.
My lord, sir, respondent number 1 is 72 years. He is
Huh?
Respondent number 1 Is it about 72 years, my lord? He is presently, my lord, bedridden, my lord. Sometime may given, my lord.
You are paying for all.
I am only for 1 and 2, my
You
lord.
are paying for 1 and 2.
Yes.
And you?
I am appearing for 3 to 7. I also seek some more time for filing affidavit in opposition.
Earlier we have given you time.
Yes.
When you are filing it?
10 days time may given.
Hmm?
2 weeks, my 10 days time may given.
Okay. At the request of the learned counsel appearing on behalf of the respondent, matters stand adjourned to be listed again on 12th of June 2024. So the affidavit be filed by 27th of May 2024. The petitioner, if advised, would be at liberty to file reply. Yes, what is this, Pao?
The I
You are appearing?
I'm appearing on behalf of respondent number 1 to 9. Plaintiff.
And
The rest of the defendants in the statute and
we are not concerned with the performer. What is this delay of what?
93 days.
Why?
Lordship, we were unaware about the passing of the order.
Why?
Lordship, the matter was pending since long and
It was an injunction matter.
yes, Lord.
Then why?
We have stated in paragraph 5 that we went to the office of the advocate. He intimated us that he could not inform us because of his sickness and there is an adverse order against us. We took the copies and all, and by the time we filed, there is a delay of 90 days. So otherwise, we are the owner of the scheduled land by way of a registered safety.
Who is the advocate?
Lordship, that is something I'm sorry, Lordship, I am not aware, but his name. I have to ask my friend.
If you don't know about his name, why should we take it? Consider it. You can't blame the advocate. How can you blame the advocate? 93 days in a first appeal, I would have done it. But against the first appeal against an order, why should we? Order was passed against what?
Against the under order 39, Lord.
What is the order passed?
Lordship, there is a status quo has been passed against. Lordship, may I read the operative part, page 96.
Now, at this stage, it is difficult to decide whether the plaintiff is entitled to his get his share of the time. However, are you going to sell the land?
No, no.
Why you are filing the appeal?
Lordship,
The only injunction is directed to maintain status quo regarding alienation and transfer of the suit land.
correct, Lord. But Lordship, the prayer in their injunction application itself, that there should be an injunction in respect of Schedule B property. An injunction has been granted in respect of the entire property. And also, I am a title holder. I am in possession. They have not averred that they are in possession. And the suit has been filed after 11 years of sale deed. They have not stated a single averment when they came to know about the sale deed.
That is immaterial. You are not selling it. Why is it meant? Only Schedule B.
And the order is against the entire suit land. And moreover, Lordship, they have challenged my sale deed, but they have come up after 11 years. They have not stated anywhere in their brain when they came to know about the sale deed.
That is why we are not concerned. As of now.
Lordship, suit property or a portion of the suit property has been acquired by the government.
You're not telling it. Then you condone the delay, dismiss the appeal, holding entirely that the injunction shall be limited to Schedule B.
In respect of the Schedule B,
Huh.
five bigger, because their intention to sell.
Only Schedule B.
Yes.
It cannot be AR because he is not going to sell it. Better?
Lordship, in respect of Schedule B, correct? Lordship, schedule, they have, in the Schedule B, they have not mentioned even the tag number. Lordship, may kindly come to page 74.
Schedule B, page 31. Page 31.
Page Lordship, they have not mentioned the tag number.
Why? Why do you say that?
Lordship, may kindly come to line number 3 of the Schedule.
What does it say?
Land measuring 2 bigger, 2 cutter, 10 less are covered by tag number blank. And
Hmm.
in the original petition also it is blank. And more so, Lordship, one of the land is covered by tag number 120. 5 bigger, 2 letters, then out of which land measuring 3 katta, 18 letters is covered by 120.
Hmm.
The tag number 120 covers land measuring 2 bigger.
Hmm.
If they are concerned with only 3 katta, 18 letter, one of the boundary in the schedule has to be tag number 120. So the boundary itself is a wrong bound. The boundary of the Schedule B, in Schedule B, there are 3 tag. And one of the tag is tag number 120. Entire tag number 120 covered around 2 bigger land. And they are concerned with only 3 katta. So one of the boundary has to be tag number 120. Out of 3 tag, they have not mentioned 1 tag. And the boundary is also primarily wrong.
No. Kindly come to page 8, paragraph 8, page 24.
But boundary otherwise also boundary because
You're not selling it.
I'm not selling it, but my land, my title is being restricted otherwise.
You want to
Because-
sell it.
I don't want it.
Nothing is it. There's one way or the other.
Lordship-
If you sell it tomorrow, third party rights will be great.
They will be protected by Section 52 otherwise.
You know what will happen that day, one matter, because of that, and all because of this builder, this has happened. All these people out there, what do you call the person who purchased the flat were in great trouble because of that. It was a case where a suit was filed seeking, the plaintiff was the person who filed a suit seeking that he cannot be evicted without following the procedure. Defendant filed a counterclaim stating that look here, we are the owners of the land, he has made all these fraudulent documents out there and all these things are there. Then the suit was decreed in favor of the claim. Thereby there was a decree for eviction, for declaration of right title. Now, this person who was the builder started constructing. He constructed the flat, and thereupon there was no injunction granted as regards construction. Constructed, sold all these flats. First appeal, filed by the builder was dismissed. Matter came up in second appeal. I was there. I dismissed it. Matter went to Supreme Court. Supreme Court dismissed. Now, this person who wanted the land at that point of time was the landlord. He has gone for execution for bringing that 6-story building. Rightly so. Now, once this has happened, the other side, these people were not informed. And because of that, now they are filing application after application. Nothing is there. He cannot do anything. They're bound in view of Order 21, Rule 102. Now, you want this same fate to be there of your purchaser?
Lordship, only my limited fear, last more than 1.5 year, evidence, it is in the stage of SBP. So, because otherwise, if it continue, I will be suffering. They have come up after 11 years. They have challenged my title deed.
That is a
In
very
fact, I have not purchased from the
very reasonable thing. We can very well direct the learned trial court to dispose of the suit within 8 months. In
The delay due to his part. They have filed 2 applications. One is for production of document, another is amendment of the appropriation. Their part is delayed. Now the suit is fixed for evidence. The plaintiff is ready to file evidence. But due to their part, it has delayed. Now they want to selling the property.
now,
it
if
will
you
be-
get that order to dispose it of within 8 months, and then your application under Order 6, Rule 17 will be gone for us. You want that?
So I have to take instruction because I was told that it is in the stage of SBP. I
Hello?
have not filed it.
Take all these instructions whenever you feel that. This court is not condoning the delay in this matter. Only ground of condoning is dismissal of the appeal and clarifying that it should be only limited to Schedule B.
I'm applied.
No, what do you want?
Only in respect of state.
Yeah, okay with that.
I have to plot. Because of the lapses, I have to pay.
This is an application for condoning the delay of, this is an application under Section 5 of the Limitation Act 1963 for condoning the delay of 93 days in preparing the connected appeal against the order dated 22/11/2022 passed by the Learned Court of the Civil Judge number 1 Kamrup Rural at Amingaon in Mizre case number 87 of the 2019 arising out of title suit number
68 of it 90.
68 of 2019. This court have perused the grounds which have been mentioned in the said application, more particularly paragraph number 5 to 8, 5 to 9. Mr. The learned counsel appearing on behalf of the respondent submits that he has no objection to the said condonation of delay. Accordingly, this court having found sufficient cause explained in the application and there being no objection, the delay of 93 days in preparing the instant appeal, accompanying appeal is condoned. I sense disposed. Oh, not possible. List the the registry is directed to register the accompanying appeal and list the matter before this court on 10/5/2050. Yes, what is this?
Respond number to expert, I filed the pre-application, Lordship. IS civil number 2807 is the delay.
Delay.
Delay, Lordship. 2859.
2859. Okay, why?
Lordship, what happened in this is the second second appeal was dismissed for default. So we are not the council. So after knowing about that, Lordship, we filed one petition for readmission along with delay condemnation petition. When notice, Lordship, issued Lordship in that delay condemnation petition, that information came that the response number 2 expired. That's why the
So it is yet to be restored.
yes.
I have filed the wakalatnama for respondent number 1, Your Lordship.
We,
But no, but however, we
Service
have
is
returned the
complete.
brief, Your Lordship.
Huh?
We have returned the brief. I may be permitted to withdraw the wakalatnama by filing appropriate application.
entered appearance on behalf of the respondent number 2, 3, 4,
respondent is
and
respondent
5.
for one,
Who is
other
respondent number 2, 3, 4, and 5?
They are the performance, 2 experts. They are the performance, 2, 3, 4, 5 performance.
And who is the person who died?
Respond number 2.
Respondent number?
2.
Binoy Burwa.
Yes.
And 3, 4, 5?
Their lordship 6 experts, but the lordship 3, 4, and 5 are the legal layers of 6.
And who is 1?
1 is the main respondent. He is the defendant.
Nilakam
He is the main respondent. Defendant.
Are they the performer?
Yes.
Why you are doing all this performer
It
business?
is lordship in main second appeal lordship that they are the party. That's why in the readmission petition I have to make them party. That's why.
In the main second appeal, they were main respondents.
No, lordship, they are part.
Then what is all this thing?
It's also they are not.
They
They are
are
not
paying for one.
I was appearing for 1, Your Lordship, but we have returned the brief, Your Lordship.
You return the brief. You want to fight against these 2, 3, 4, 5, 6?
Otherwise, no, they did not in fact appear in the.
So all these things not necessary. We say that
Yes.
matter over. Why should we go into all these delays and all? Then we take up the application for
Delay lordship.
restoration. No,
There is also delay lordship
for what?
for in the readmission.
He's appearing.
That is 1934 of 22.
How much delay?
There is also 3978.
How much?
397, 3,978.
Lako. 18 ikon IA 2809, 2808, and 28. The above 3 applications are filed for condonation of delay, setting aside of the abatement insofar as the respondent number 2, performer respondent number 2, as well as for substitution of the legal representative of the performer respondent number 2 in the accompanying appeal. Ms. P. Butcherjee, the learned counsel appearing on behalf of the applicants submit that that the performer respondent number 2 did not participate in the trial or even in the first appellate stage. Under such circumstances, this court is of the opinion that under such circumstances, the learned counsel therefore submit that the name of the performer respondent number 2 can be struck off. In view of the submit that the performer respondent number 2 did not participate, accordingly it may be struck. Accordingly, the name of the performer respondent number 2 is struck off. And did not participate in the said proceedings. The learned counsel therefore submits that she would not like to press the 3 applications. Accordingly, the 3 applications stands closed. Then IA 1934. One is restoration in here. Why? Why the delay?
But the delay is what happened, lordship, in this case, because appeal was dismissed on 24/3/2009. There was other state of counsel that was not informed by the lordship, the client lordship.
Why was it dismissed for divorce?
for non-appearance.
Why?
Order is I have annexed Lordship page 13 of my application. Property portion at Lordship page 16. Non-appears, appeal is dismissed for default.
Ah.
So thereafter, Lordship, in the year 2021, Lordship,
Let's go to the courts of the The counterclaim was beyond the pecuniary jurisdiction.
it was counterclaim allowed.
No, was beyond the pecuniary jurisdiction. What was the value?
Have 21,001.
Then
Here they have
counterclaim is 21,100. That means it is less than 25,000. At that point of time, 25,000 was the. Then the
And-
first question of law does not arise. Second is nothing is.
still Lordship,
We do one thing. We restore it, dismiss.
Lordship, we exclude then Lordship, I may be allowed to argue the second appeal, otherwise,
Argue. We have time.
not today, Lordship, some
I
other
don't
day,
have any
Lordship,
matter.
because
There's no matter.
in
Lord.
second appeal, I will argue, Lordship, not married, Lordship,
Nothing. Argue this.
not today, Lordship.
How does the first substantial question of law arise? Tell me.
That I have not read in regarding second appeal, that it will be hard by some other day. Day after tomorrow, Lordship.
Take it off. No? List these two matters. Treat these matters on on restoration of condonation on 1934 of 2021. This is the matter on 10/5/2020.
Public.
I will. You see, you are not going to argue. You are only to satisfy me that you have a case. If you have a case, then only the question of thinking of
Restoration,
condoning will come.
that we
Otherwise, no. You have to have a very good case, more than a normal case. And you don't go away, mister. Take some credit. Hey, এখন তাও তুমি বলবো।
Made.
Hmm.
There are three interlocutory applications.
Hmm.
One is, my lord, 3,200, that is delay for delay condonation.
Hmm.
And my lord, miscase
Delay
80,
condonation for what?
readmission of act. That is in 81. Miscase 81. Your lordship may turn to page
The delay is 193 days.
1.
Yes.
My lord, your lordship may turn in the miscase 81 of 2023.
Huh?
Miscase 81 of
3,200.
3,200 is for delay control.
That we have to first see, then only we can go to the other.
The only
Yes.
ground is, my lord, Dr. Ahmed was there, and because of his illness, and eyesight and diabetes and other kidney problems, he has stopped coming to court. And that was the reason why it was dismissed for default. Para 6, my lord.
My lord, kindly see the order of dismiss for default on 28/2/2023.
And what is this IA 3201?
3201, my lord, there was stay of execution because the appellant came to know about the notice of the execution and approached the court by the stay of the execution. There was the order passed.
Where?
My lord, in ISP 201.
So how can this court pass an order?
Pendency of the taking consideration that the repetition application.
But this court would get a jurisdiction if there is something substantive. Without the roots, you are just going on the stem.
Voilà. Because on the under the section 151 of the Code of Procedure, for some substantive
You can very well ask under Order 21 or 26. But how can this court exercise the jurisdiction under 151 if nothing is there?
my submission at this moment, your lordship, because this is the second appeal of 2004, all the counsels for the appellant and the defendant are satisfied, or they have stopped coming. But from 2004 till 24, no substantial question of law was considered till then.
My lord, kindly see the conduct in the from the very beginning of the second appeal. Earlier, 3 times it was dismissed for default. On last time when it was restored, with
Second
the
appeal is
condition that
directed
it will
against
be
the
heard
judgment
on
and
next
here
date.
passed by the dismissing the while the matter was pending for admission and here it was dismissed for non-application. On an application which was registered, the second appeal was restored by the right. Thereafter, when again none appeared on Iman and the none appearing on the act withdrawn from the case, a notice was issued to the appellant. Thereafter, the appellant made the absence consecutive that the matter was for take the fact the order is operating, suspending the execution was dismissed. However, yet another application for historic may not appear up.
The appellant was the defendant, the respondent was the plaintiff. Their suit was for first position and followed for base profit.
Yes, 2004. The court passes an order, a pending notice stay. The court doesn't get the jurisdiction without framing a substantial question of law.
That
Yeah.
only thing
Conduct is not good.
only thing that if your lordship public to argue. I know I don't have access. Only thing the dismissal because of the council, because he has stopped coming currently and there's a lot of criticism.
Okay, argue.
A lot.
Argue.
The case of the plaintiff was that for the plaintiff says your lordship will find.
What is the substantial question of law?
My substantial question of law, I have framed it.
देखिए आप तो
Yes, let's see your plaintiff. You are the defendant?
Defended by written statement, my lord, your lordship will find in that way. Start at page, my lord, 48. And the 10th pair is at, my lord, 45.
Yes, read page 51.
My lord, that is what I'm. In fact, in middle portion, my lord, I'm.
The said suit was ultimately dismissed due to default
Well.
caused by the continuous illness. Although the said title suit was dismissed, the defendant cannot be said to be the permissive occupier of the suit premises, as they are in fact occupying the same as their own since immemorial and without having any knowledge and information of the ownership of the plaintiff's predecessor, Day, and after his death, the ownership of the plaintiff, and without acknowledging their right and title over the suit property. What do you mean by that?
Well, thereafter, due to such long and continuous hostile occupation of the suit premises against the interest of the plaintiff more than the statutory period.
When? Since when?
My lord, because here the grandfather of both the plaintiff and the defendant are the same. They are the grandfather was occupying the plot of land, my lord, from 1956. Now the plaintiff, the joint who has come, the husband of the plaintiff, my lord, got married in 1956. So, my lord, after the death of the grandfather, both the fathers, Ramesh, the defendant's father and the plaintiff's father, both are occupying the plot of land. My lord, they have purchased the suit land.
Plot of land against whose land?
That was Mahesh Gaurav. Mahesh Gaurav.
Then,
my lord,
now who is the owner?
My lord, the suit was purchased by the plaintiff in 1971 in different sales. And from 70, if I take it from 1970, my lord, though the previous position was there, my lord, they have only filed the suit in, my lord, 1993 and state that you should vacate the land. So, my lord, from 1971, if I take it, so we are in that first position. But while deciding,
how?
Because, my lord,
where have you mentioned that?
That is at page that para. My lord,
where?
My lord, in page 51. Due to such long and continuous.
No, that is not there. That cannot constitute a plea of adverse possession. The plea of adverse possession has to be categorical. It is saying that from when you have been in adverse possession to the true owner. You say that you don't know who is the true owner.
Because, my lord,
because they won't help it. That is the ground. That is the law. You have to know against whom you are possessing adverse. You can't be possessing adverse against all. The possession of yours has to be adverse to the
And
true
open,
owner.
and it should be
Where
open.
is it?
It should be open.
Open is okay, but against whom?
Not, because here, that line, as your lordship says, without having any knowledge and what
Let's restore it and then dismiss it
Mala,
without order 41 rule.
that much your lordship, I do it. That much. I know, my lord, I have.
At last something finished. But it is very sad that a notice is being issued in 2004 and we are still at the stage of order 41 rule 11. Anyways. How many ayahs?
My lord, 3 eyes.
This court is not going to consider the 3201.
Fine.
81 is restoration.
Readmission.
Readmission. IA 3200/2024. This is an application filed under Section 5 of the Limitation Act for condoning the delay of 193 days in filing the application under Order 41 Rule 19 of the Code of Civil Procedure for restoration of readmission of the regular second appeal, which was dismissed for non-prosecution by the order dated 28/2/2022.
It was dismissed on, my lord, 28 to 23.
20?
28,
23.
23. This court have perused the application and have heard the learned counsels appearing on behalf of both the parties. From a perusal of the said application, it reveals that on account of the illness of the counsel, Dr. B. Ahmed, the state counsel could not appear before this court when the matter was taken up for hearing. Further to that, the said counsel, on account of his ailment, also could not inform the client, inform the appellants. However, it was only at the stage when the applicants received the appeal memo, the notice from the executing court, they came to learn about the dismissal of the appeal, for which the accompanying application under Order 41 Rule 19 of the Code was filed, registered as Miss Case Number 81/2023, along with the instant application for condoning the delay of 193 days. This court, taking into account the above materials, is satisfied that the same constitutes a sufficient cause in condoning the delay of 193 days, for which the delay stands condoned. I stands disposed. Miss Case Number 81. This is an application under Order 41 Rule 19 of the Code of Civil Procedure, seeking restoration of readmission of the regular second appeal, being RSA number 96/2004, which was dismissed for non-prosecution by an order dated 28/2023. The grounds mentioned therein stipulate that the earlier counsel who was representing the appellant could not appear on account of his medical ailment, and further, due to his medical ailments, he could not also inform the applicant. Taking into account the grounds which are solely on account of the ailment of the counsel, this court is of the opinion that the case is made out for readmission, for restoration of the appeal, restoration of the appeal, which was dismissed for default by the order dated 28/2023. Accordingly, the instant application is allowed, thereby bringing back the regular second appeal number 96/2004 to the file of this court. I extends the court. Econ, regular second. Heard Mr. P.K. Roy Chaudhary, the learned counsel appearing on behalf of the appellant, and Mr. S.K. Ghosh, the learned counsel appearing on behalf of the respondent.
Number 224.
When?
One died and 224 are the legal years of one.
Appearing on behalf of respondent number 224. The instant appeal is directed against the judgment and decree dated 26/3/2004, passed in title appeal number 23/2002, whereby the appeal was dismissed, thereby affirming the judgment and decree in title suit number 23/96, dated 22/5/2002. The question which arises, the instant appeal is being taken up at the stage of Order 41, Rule 11 of the Code of Civil Procedure 1908, for short the Code, to ascertain as to whether the substantial question of law so proposed by the learned counsel appearing on behalf of the appellant can at all be formulated in terms with Section 100(4) of the Code. The learned counsel appearing on behalf of the appellant had placed before this court had proposed before this court the following three substantial questions of law, which can be formulated in terms with Section 100(4) of the Code. The same is reproduced here in under 1, 2, 3. 4 to nalagati. The question arises as to whether the said substantial question of law so proposed can be at all formulated in the instant appeal. For deciding the same, this court briefly would like to take note of the facts involved in the instant appeal, the facts leading to the filing of the instant appeal. You are a plaintiff. The respondent numbers 1, 2, 3, and 4, 1 to 5. The respondent numbers 1 to 5 as plaintiff had instituted a suit seeking recovery of khas possession of the suit land by evicting the defendants, semicolon, for compensation of mean profit for unauthorized use and occupation of the suit premises, etc. The claim of the plaintiffs in the suit was that the defendant number 1, Srimati Hemoprabha De, was married to, was the first wife of one Ramesh Chandra De, who was the elder brother of late Biseswar De. the predecessor in interest of the plaintiffs. The said defendant number 1 used to occupy the suit premises as permissive occupiers with her children. At first, under the predecessor in interest of the plaintiff, late Biseswar Day, and after his death on 6/4/1981, under the plaintiffs. It is the case of the plaintiffs that out of case of the plaintiff that taking into account the helplessness and miserable situation of the defendant number 1 and her children, and there was no shelter. The plaintiff, the predecessor in interest of the plaintiff as well as the plaintiff, permitted the defendants to reside in the suit premises. However, the husband of the defendant number 1 instituted a title suit number 18/1986 in the court of the learned Assistant District Judge Jorhat against the plaintiffs and the performer defendant number 2, claiming right, title, and interest over half share of the land in that suit alone and confirmation of joint possession thereof. The case set out by the said Ramesh Chandra Dey was that he contributed the entire consideration of rupees 30,000 in installment in respect of the 3 kathas of land and paid to the owner Mohesh Chandra Buraguahai through his brother Biseswar Dey, but the later obtained the sale deed, executed and registered in his name alone, excluding Ramesh Chandra Dey. However, the said suit was dismissed on merits ultimately. It was the further case of the plaintiff that the entire land of 3 kathas, as covered by DAG number 4748 of PP number 132 in block number 2, Jorhat town, with standing structure with a garage, including the suit premises, was the self-acquired property of late Biseswar Dey. Late Biseswar Dey was a tenant earlier in a portion of the above land and paid a sum of rupees 1,500 as advance for purchase of the entire land of 3 kathas, by receipt dated 24/3/1965, to be paid in installment, and paid the consideration money of rupees 20,000 and got the sale deed executed and registered on 12/12/1970 in respect of 2 kathas of land, and thereafter paid the sum of rupees 10,000 and got requisite sale deed executed and registered on 30/8/1973 in respect of 1 katha of land of the same dag and patta from the owner Mohesh Buragohai. It is on account of the actions of the husband of the defendant number 1 as well as the defendants not inclined to vacate the suit premises. The suit was filed seeking for the declaration, seeking for the relief as already stated here in above. The defendant numbers 1, 2, and 3 jointly filed a written statement denying the contents of the said of the plaint and further stating that the defendants were not in permissive occupiers of the suit premises, as they were, in fact, occupying the same as their own since time immemorial, and without having any knowledge and information of the ownership of the plaintiff's predecessor, Biseswar De, and after his death, the ownership of the plaintiffs, and without acknowledging their rights and title over the suit property. It was stated that due to such long and continuous hostile occupation of the suit premises against the interest of the plaintiffs more than the statutory period, the defendants have acquired the right, title, and ownership over the suit property on termination of all types of right, title, and ownership of the plaintiff, if they had any. On the basis of the above, pleading, as many as 6 issues were framed. Issue number 2 pertained to as to whether the suit was barred by limitation. Issue number 3 was in relation to as to whether the defendant numbers 1, 2, and 3 were permissive occupiers of the suit premises. And the issue number 4 were whether the plaintiffs had any right, title, and interest over the suit land. The learned trial court, by their judgment and decree, dated 15/5/2002, decreed the suit in favor of the plaintiff. The issue number 2, which was an issue pertaining to limitation, was held in the negative and against the defendants. As regards the issue number 3, the learned trial court held that the defendant numbers 1, 2, and 3, on the basis of the evidence on record, had opined that the defendant numbers 1, 2, and 3 were permissive occupiers of the suit premises. In respect to the issue number 4, the learned trial court, on the basis of the evidence on record, held that the plaintiff had right, title, and interest over the suit land on the basis of the 2 registered deeds of sale. Exhibited as Exhibit 2 and Exhibit 3. Consequently, the other issues were also decided in terms with the said 3 issues. Being agreed, an appeal was preferred by the defendant numbers 1, 2, and 3, which was registered and numbered as Title Appeal number 23/2002. The said appeal was dismissed by the judgment and decree dated 26/3/2004. By deciding the said appeal, issue-wise, it is against the said the instant appeal have been filed, challenging the judgment and decree dated 26/3/2004, passed in Title Appeal number 23/2002. In the backdrop of the above, let this court now consider as to whether the substantial questions of law so proposed can be formulated by this court in exercise of the powers under Section 100(4) of the Code. This court have heard Mr. P.K. Roy Chaudhary, the learned counsel, appearing on behalf of the appellant, who submitted that the entire case of the appellant herein was appellant as defendants was that they were in adverse possession of the suit premises of the suit land. And on the basis thereof, the substantial question of law number Roman 1 and Roman 3 have been proposed. He submitted that the learned trial court as well as the first appellate court while deciding the issue number 3, failed to frame and or determine the question of adverse possession of the defendant numbers 1, 2, and 3. And this aspect if would have been done so, the course of the appeal, course of the entire proceedings would have been in favor of the defendants. He further submitted that as the suit is based upon Article 65 of the Limitation Act 1963, Article 65 of the Schedule to the Limitation Act 1963, the plaintiff was required to come within a period of 12 years the plaintiff was required to file the suit within 12 years. Which was, however, not done in the instant case. Inasmuch as the suit was filed in the year 1993. In addition to that, the Learned Counsel also submitted that the Learned First Appellate Court did not decide the suit in accordance with Order 41, Rule 31 of the Code by not framing the point for determination and the reason for the decision. On the other hand, Mr. S.K. Ghosh, the Learned Counsel, appearing on behalf of the respondent, submitted that when the issue number 3 related to permissive occupier, the defendant's defense was duly taken as to whether the possession of the defendants were adverse to the true owner or were permissive in nature. And the learned and both the courts below, which are the courts of facts, have given a concurrent finding of fact that the petitioner herein, that the appellants herein were permissive occupiers. He further submitted that to claim adverse possession, the claimant is required to the burden of proof that is required to not only plead but also prove that the claimant was possessing the property, immovable property, openly, hostilely, and with the due knowledge of the plaintiff, with the due knowledge of the true owner. referring to the written statement the learned counsel for the respondent submitted, that it is an admitted case of the defendants that they did not know who was the true owner. And as such, the question of adverse possession so submitted does not arise at all. The learned counsel further submitted that a suit based on title can be filed. The suit based on title claiming possession can be filed and submitted, that there is no limitation for a suit based on title claiming possession unless the defendant proves that the defendant had been in possession for a statutory period of 12 years adverse to the plaintiff. And as such, the substantial question, the third substantial question of law, the first, the Roman 1 and Roman 3 substantial questions of law are totally misconceived. The learned counsel further submitted that that the learned first appellate court have duly considered the grounds of objection so taken, and on the basis of that have decided the suit, the appeal issue-wise. And as such, there was no infraction to the provisions of Order 41, Rule 31 of the court. Anything else? I've heard the learned counsels appearing on behalf of the parties and have given due anxious consideration to the respective submissions. The substantial question of law number Roman 1 and Roman 3, which have been proposed, are in relation to adverse possession. Under such circumstances, this court finds it very pertinent to observe what is required to prove the plea of adverse possession. To prove the plea of adverse possession, A, the plaintiff must plead and prove that he was claiming possession adverse to the true owner. B. The plaintiff must plead and establish that the factum of his long and continuous possession was known to the true owner. C. The plaintiff must also plead and establish when he came into possession. And D. The plaintiff must establish that his possession was open and undisturbed. This court finds it very pertinent to observe that if the defendant sets up a defense of adverse possession, the defendant has to prove the above. It is also a well-settled principle of law that by pleading adverse possession, a party seeks to defeat the rights of the true owner, and therefore there is no equity in his favor. After all, the plea is based on continuous wrongful possession for a period of more than 12 years. Therefore, the facts constituting the ingredients of adverse possession must be pleaded and proved by the plaintiff or the defendant, as the case may be. In the instant case, if this court duly takes note of the written statement, it will be seen that the plaintiff, that the defendants are not aware against whom they were possessing, against whose rights they were possessing. Inasmuch as they categorically state in their written statement, inverted comma, without having any knowledge and information of the ownership of the plaintiff's predecessor, Bisesor, and after his death, the ownership of the plaintiffs, and without acknowledging their right and title over the suit property, inverted comma close. This court also finds it very pertinent to observe that the written statement is completely silent from what date the plaintiffs, the defendants claim to be in adverse possession. There is also no mention whatsoever as to how the defendant's possession was open and undisturbed, was open and hostile to the true owner. Inasmuch as no materials, facts have been stated in that regard. Under such circumstances, without those pleadings, the question of adverse possession does not arise. The learned first, in this regard, if this court duly takes note of the decision of the learned trial court, as well as the learned first appellate court in respect to issue number 3, it would be seen that the learned trial court as well as first appellate court had, on the basis of the evidence on record, have come to a finding of fact that the defendant numbers 1, 2, and 3 were permissive occupiers. And this finding of the learned trial court and the learned counsel appearing on behalf of the appellant could not show before this court any perversity in the findings so arrived at. Consequently, in the opinion of this court, the substantial question of law so proposed at serial number Roman 1 and Roman 3 does not arise, which can be arise. As regards the substantial question of law proposed at serial number Roman 2, it would be seen the learned first appellate court have duly taken into consideration the grounds of objection and on the basis thereof have decided the said appeal issue-wise by taking each issue as a point of determination. And as such, this court is of the opinion that the said impugned order is in conformity with the provisions of order for impugned judgment and decree is in conformity with the provisions of order 41 rule 31 of the court. Consequently, the substantial question of law so proposed at serial number Roman 2 does not arise. Consequently, in the backdrop of the above, if this court now takes note of that in the backdrop of the above, this court has therefore have arrived at an unhesitant opinion that no substantial question of law can be formulated in the instant appeal under section 100 bracket 4 of the code, for which the instant appeal stands dismissed with cost quantified at rupees 50.
That may not.
50.
But we will be executed. At this rate. We will already be executed.
Not executed. You have spoiled so much of time. No councils have taken this court for a ride. Hey, on the 3,200 in view of the dismissal of this, the state order stands vacant.
My lord, in trial court order, not 25, it is 15 fine.
Okay. At last, it has come to an end.
At last, it has.
Because otherwise, if I restore, and then again the matter will come up. So this needs to be finished today. Today I had a lot of time. There is no matter.
My lord, regarding cost.
A cost of 10,000 for the instant proceeding, and further, the appellant hearing and the respondents, the plaintiffs would be entitled to cost throughout the proceedings.
What you are?
Ridiculous. Yes, what is this? Within time.
Within time, Lord. Within time.
Okay. This is an application under Order 22, Rule 4 of the Code of Civil Procedure, 1908, for substitution of the legal representative of the respondent number 1 who expired during the pendency of the expired on 31/12/2022. Why do you say it is within time?
Lordship, we came to know it on 10/9/23.
Huh?
We came to know only on 10/9/20.
You have the CPC with you. Take the CPC. Read Order 22, Rule 4, bracket 5. Yes. Yes, let us be enlightened. What does he say?
Order 22.
Rule 4, bracket 5.
Where A, the plaintiff was ignorant of the death of the defendant and could not for the reader make an application for the subscription of the legal representative of the defendant under the rule within the period specified in Immigration Act 1963, and the suit has been consequent abated, and the plaintiff applies after the expiry of the period specified therefore in the Limitation Act 1963 for setting aside the abatement and also for the admission of that application under section 5 of that act on the ground that he had by reason of such ignorance sufficient cause for not making the application within the period specified in the state act. The court shall, in considering the application under the state section 5, have due regard of the fact of such.
So, tell me.
5 application.
Then, not section 5. Here is a case 60 days, 90 days, 60 days, and then 5. We need another 2 applications. And Mr. H. Buragwai, an expert in civil law, you were saying within time. Don't make this type of submission. Mr. C. Sharma, the learned counsel appearing on behalf of the applicant, submits that he requires some more time to file a further 2 applications in the. Now clear with the provision?
Okay.
Yes, Mr. BK sir.
Hello,
What is this?
IA has been
I'll get a
filed,
matter.
Milord.
I for what?
IA is filed, Milord, in view of the order passed by this court.
What did I do?
Milord, what has happened?
Yes. What order did I pass?
Milord, earlier occasion, your lordship is filed. In
No,
here,
this is not my order.
No.
this
Then
is
how
not-
can I take up?
This is subsequent. This is subsequent I have come.
What?
Milord, for same cause of action, Milord, because Milord,
Just
fi-
Sen, kindly come to the point. Don't digress. Is this my order?
there was an order passed by the court.
Lordship, may I submit?
Yes.
Milord,
Lordship, he filed an application before the
let
trial
me-
court
let me
under
conclude my-
order 7, rule 14. That petition was rejected earlier. Against that, he preferred a revision. And that petition earlier revision was disposed of by the Honorable Court by the order dated 26/11/2021, directive allowing them to submit the document A series to produce the document at the time of cross-examination of my witness and subject to admissibility of the document by the court. That was there. So accordingly, he cross-examined my witnesses on the 3 dates. Thereafter, suddenly he filed another application on the same ground under order 7, rule 14, read with under order 13, rule 1(3). And considering that honorable court's order, the learned trial court rejected his application again because now he again wants to produce that document, consider document as an evidence on record. Then learned trial court rejected his petition. Against that, he filed this application, present revision application, which is pending before his honorable court. And in that application,
Right, submit.
And then?
then
Milord,
then on the last occasion, Your Lordship, there was an order
Order for what?
order, Milord,
Order passed by whom?
Passed by this honorable court.
Malasthi Nandi, Justice Honorable Justice Malasthi Nandi.
Or then?
My lord, just
By that petition, by
And
that order,
he wants what? Correction.
for correction, my lord.
correction of the
In the application, my lord, that has been filed by the court.
29/1/2024.
My lord.
That is not an order passed by me.
No,
No, my
Don't
lord.
spoil the time. It has been submitted at the part by Mr. P.K. Sen, the learned counsel appearing on behalf of the applicant, that the instant application being IAC 533/2024 is an application seeking certain typographic, certain corrections in terms with section 152 and 153 of the Code of Civil Procedure 1908 for an order passed for as regards an order dated 29/1/2024. The said order has been passed by Honorable Mrs. Justice M. Nandi, who's taking into account the raised fees directed to list the matter which was appropriate. That was a simple thing. Why are you beating around the bush?
Lordship, already he filed an IR application.
My lord,
The
I
method
said-
can be disposed of by the honorable court.
I thought.
Which
my lord,
This one.
Why?
Already
once-
that IR application was filed.
My lord, I thought, my lord, that your lordship may also take up. That's
Which
why
one?
I did not
The
mention
main
it.
matter.
No, no,
Lordship,
no, my lord. The IA that has been filed
Correction.
in view of the order passed by the my lord justice.
So
I
that is
thought-
why I sent it there.
Yes.
Don't make it.
All right.
Yes, what is this I for? এবাৰ হৈছে দেখোন এনেকুৱা এটা কেছ কৰি Mr. Mate again on fifth of June. এখানে আরো কোনো ভরসা নেই যে তো অর্ডার কেন क्या है तो इनको आपकी ठीक करो नहीं yes what are these
I have the appeal at Lordship.
Huh.
And if you find the appeal, I have filed one Jackson appeal.
Huh.
2021.
Huh.
That 2021. Then 2020 Lordship have started construction.
Hmm.
So I have filed one additional appeal. After that, status quo was granted by the court. Then the respondent filed an application for modification of that status quo order in one to construction. That IA Lordship no order was passed. Then it started construction. So I have filed violation. On last, there's an order to bring
Look, in the violation petition, I do not have it. In violation petition, I do not have it.
and the matter is for
8/4/2024 heard Mrs. R. Chaudhary Learned Counsel appearing on behalf of the applicant and also heard Mr. S. Sahu Learned Counsel appearing on behalf of the opposite party. Mr. S. Sahu prayed for some time to take instructions.
Yes, my lord, because this is a different proceeding, my lord. Notice it there to the party with that party contract. Since this, my lord, there is a penal provision is also there.
You have your injunction application pending. You direct the police to take it. Where is that order?
injunction
IA
IA
238
238.
238
Correct.
238. There is an order passed.
Yes. Status quo is to be maintained by both the parties.
এখনো লিখব হ্যাঁ টু IA civil 238 of 2021
Code 8 2020.
no no IA 238 of 2021 na
On Code 8 2023, there is an order in IA.
4/8/2023 okay good. It has been alleged by the learned counsel appearing on behalf of the applicant by filing an interlocutory application being IAC 867/2024 that the respondent opposite party herein, namely, who is doing it?
Lordship, of the death of Nazir Ali, he is legal heir.
Who is doing it? The opposite party number 1A to 1F are acting in violation to the order passed by this court on 4/8/2023 by making construction,
They have started contrary wall of
by making constructions by by putting the tin over the construction and also plastering the inside wall of the said construction. Full stop. This court directs the officer in charge of which police station? What? Tezpur. There is a Tezpur police station. Officer in charge of Tezpur police station. Are you sure?
Lordship, Bebesia output. I have met page 6, Lordship, paragraph
Of
Bebesia Police Outpost.
Where?
Page 6, Lordship, para 3. It started from page 5 that during the pandemic.
This court directs the officer in charge of Bebesia Police Outpost to make a spot inquiry upon production of a certified copy of the instant order as to whether any construction is being carried out over the land. Which land?
Lordship, that land mentioned in the schedule of the plain. It is an inherited property and we have also share over the same plot of land along with my brother.
Huh?
He is my brother, Lordship. The Nazir Ali died together, so brother.
Dispute was in between brother and sister.
Okay.
And we have filed one FIR also that I have enclosed along with my affidavit in
This appeal is by you.
Yes. By
You
the-
lost in the trial court.
No, Lordship. Trial court granted 2/3. Our claim says we are entitled for 2/3 along with our brother. Trial court decreed then they filed the appeal. Appellate court had said I am entitled for 1/8 for each of the sisters. But in fact, Lordship, 2/4 of the property will be given to the two sisters and 2/4 will be given to the son. Our prayer was also wrong.
You are entitled to how much?
4 or 2
How?
sisters, 1/4, and the second 2/4 will be the son.
2/4 means half.
Yes,
Half will be son.
yes.
And you are
And
going to get half.
another half will be distributed among two sisters equally. In
You are
moment,
entitled to 1/8.
no, Lord, one, I am the Lordship, daughter of a Mohammedan, so I am entitled for half of the share, and the son is entitled for double of the share. So entire property is to be divided to 4
No,
parts.
there were two sisters.
Yes.
So therefore you will be getting how much?
One
There's no mother.
No. The mother died. 1/8 for the wife, Mohammedan wife. Son will get the double the share of the daughter. So
There's one son.
one son, two daughters. Be divided to 4 parts. One-4 is one sister, and 1/4 one sister, and then the next half the son.
So
Then-
therefore you will get half.
Half by the two
How many sisters are here?
sisters.
Both.
Yes.
So you are entitled to half.
Yes.
The
Both
appellate.
the sisters are appellant, both the sisters are applicant.
Therefore they are entitled to half.
Half.
And now they are constructing on that half of that land or which land?
Entire land is under the brother Lordship. Only one sister is residing a part of that land. This Nurun Begum is not residing in the plot of land. Another sister, the plaintiff Nadiban Nessa, she is residing. That was not part.
To give IA 867 of the 2000. This is an application under Order 39, Rule 2A, read with Section 151 of the Code of Civil Procedure 1908, alleging violation to the order dated 4/8/2023, passed in IA Civil 238 of the 2021, whereby this court had directed that till the next stage of listing, both the sides shall maintain status quo in respect to the suit land. It was further clarified that no construction activity shall be carried out by any of the parties. The said order was extended.
Yes.
When?
Interim of the extended.
The said order subsequently was extended by an order dated 11/10/2023 till 16/10/2023. It has been alleged that the said order after 16/10 it has been extended.
Last of it, 8/4/2024. 8/4/2024.
It was extended. No, as on that date.
10 of October. It's not
No, 16/10 it was said interim order passed earlier stands extended till the next date of listing. List on 16/10.
then 1/12/2023.
Then when did this thing happen?
1/12/2023 lordship, it was
No,
mentioned
when this allegation is happened.
that I have filed this on April 2024.
Understood. When did the construction happen?
Lordship, thereafter they filed an application that is.
I'm not on that. You have to have the allegation. This court have duly taken note of that there is no mention as to when the construction was carried out in the said application. The record further reveals that there is no extension of the interim order from 16/10/2023 to 8/4/2024. And thereupon on 8/4/2024, the interim order was extended. However, the instant application was filed on the basis of an affidavit filed on 13/3/2024. Under such circumstances, this court is of the opinion that the allegations so made in the instant application does not constitute a violation to the order dated 4/8/2023, inasmuch as the said order was not extended beyond 16/10/2023, and there is no allegation made in the application that the construction was carried out prior to 16/10/2023. Accordingly, the instant petition stands rejected.
The 3049 it was extended as.
No, that is the order.
30
What happened in 3049, they extended that order on, they even does not mention in which order. It says it is extended till 16. Now, 4/8/2023 order came to an end on 11/10/2023 because it was till the next date of listing. So on next date was listing was on 11/10/2023. And it was extended till 16/10/2023. There is no extension from 16/10/2023 to 8/4/2024.
Instead of 8/12/2023, that day also there's an order. Maybe that order was passed in 3049.
That is not your allegation. That there is about that order in your application. And
Interim was there, but
there is no interim.
Lordship may fix a date for RD hearing.
Which one? File application. I'm always ready.
sister and brother's case, so they have to fix before.
What?
For hearing, before final hearing.
They have disposed of committee. How kita? You have given up till 39. What is this? What is this, madam?
Substitution of the legal year
Huh?
on the date of the applicant.
What happened?
Applicant was died on
39
39
behind the appellant at the
So
Kule.
his wife name may be substituted.
Okay. This is an application filed by the
Wife of
filed by the applicant, who is the legal representative of the proprietor, Sri Kamaikha Saha, who expired on 13/9/2023. The said application having been filed within the period of limitation and the right to sue having duly survived, the instant application stands allowed, thereby substituting the applicant herein in place of the petitioner in the accompanying civil revision petition. The counsel for the applicant is directed to file a fresh memo of party before the registry on the basis of the footstep. The registry shall, on the basis of the instant order as well as the memo of party, shall make necessary correction of the records, make correction in the cause title, and also in the CIS. I stands disposed.
and the